Good day, everyone. Magandang umaga wherever you are, or it could be good afternoon to some of you. Well, welcome to Central Books' best free week ever. So here at Central Books, what we do is that we have lectures. We have series of lectures actually, especially to our baristas. I know that you're now already towards the last few stretch of your review for the bar examinations, and of course, we're rooting for you. Of course, kaya niyan actually. And for today's lecture, actually, we have commercial law. And this is just like what I mentioned, one of the many lectures that we have for all the bar subjects, such as political law, criminal law, rem law as well, and the different bar subjects. So my name is Leonard, by the way, and I'm your host for today. We welcome you to the pre-week lecture series, and this is presented to us by ALS, or Philippine Association of Law Schools, as well as, of course, our generous sponsor, Central Books, in partnership with the Polytechnic University of the Philippines College of Law and the Association of Law Students of the Philippines National. Okay. And we would like, if you would like to be, updated or stay updated of the new lectures coming up, in the coming days or in the coming weeks, we would like you to follow, of course, our Facebook page at PALS, or the Philippine Association of Law Schools.
Now, without further ado, let us get to meet today's lecturer. Our lecturer is the presiding judge of RTC Branch 21 in the city of Imus in the province of Cavite. And she previously served as the senior assistant city prosecutor in Manila for a decade. She is a commercial law professor, actually, and she taught at different institutions such as San Sebastian College Recoletos and the Polytechnic University College of Law. As a matter of fact, one amazing fact about today's speaker is that she was recognized as San Sebastian Recoletos College outstanding alumna in 2013, and she was also acknowledged as the outstanding prosecutor by Manila in the year of 2016. She has published multiple law books with Central Books, today's sponsor, and she already contributed to notable legal publications, including her article on copyright in 795's Cross 691 and Inishi magazine. Today's lecturer has also participated in international intellectual property law programs in Japan and Switzerland. Let us get to meet Honorable Rocille Aquino-Tambasacan.
Okay, hello mga anak ko. So, we'll have a pre-week now, and since we are cramped with time, I made sure that you will be able to maximize the 3-hour allotment for this. So, I took up what's the contents of my pre-week. It contains what are probable questions that can be asked in the bar, and I highlighted also here the Justice Lopez ruling. So, hindi na kayo kailangan magkalkal ng iba pang libro, di ba? So, but of course, not everything you see in the slide, lahat na yan. You also have to supplement it. That's why I have my own book. I have my pre-book, as usual, patalastas, that you can buy now at Central Books. Okay? So, we'll start first with revised corporation code. So, ano tinatanong about corporation code? Let's start with the definition of corporation. From the definition of corporation, code lang to ha, walang hirap to. You look at the elements found in section 1. So what are the 4 attributes of a corporation? First, it is the artificial being, created by operation of law. The right of succession, the powers, attributes, and properties expressly authorized by law or incident to its existence. Pero walang bar exam na nagtatanong, give me the 4 attributes. Kasi pag tinanong yun, magtalon-talon na kastuwa. Paano siya tinatanong? How do we apply the 4 attributes? So, for example, so being the concept of an artificial being, XYZ Corporation has a debt with BIR for unpaid taxes. Can XYZ Corporation go after then the assets of the stockholders of XYZ? O yun yung application ng doctrine. Pero anong doctrine yan sa artificial being? Basic, separate juridical personality. So the personality of the corporation is separate from that of the stockholders and vice versa. So if you're a stockholder, what then is your interest over corporate assets? It's only in Kuwait. It's not yet complete, not yet partial, not yet full. Because you have to wait first for the dissolution of the corporation before you can say that a particular corporate asset is yours. Because you pay off first creditors before you pay the stockholders. Now, since the general rule is separate juridical personality, ang rule na yan lagi may exception. Okay, what exception? Piercing the veil of corporate fiction. So first, under what circumstances do you pierce the veil? I know that there's already a new definition in fraud, alter ego, equity, etc. But I still find the old traditional definition as better. Ano yun? When the corporate fiction is used to defeat public convenience, justify wrong, protect fraud, defend crime, then the shield or the veil separating the corporation from the stockholders would be lifted and set aside. And they will be considered as an aggregate of individuals. But the question is not just when do you pierce the circumstances. The question is, how do you pierce? Anong gagawin mo to pierce? So, when you file a case in court, you implead not only the stockholders or responsible officers, but the corporation also. Because if you will sue only the corporation or the stockholders only, without impeding the other, you're actually respecting the separate juridical personality concept. Okay? So, paano naman kung ang setup ay there's a principal-subsidiary relationship? Normally, the principal owns majority of the stock of subsidiary. Does that mean that there is no more separate juridical personality? Mere ownership is not enough. In order to pierce the veil, there should be a showing that there is complete dominion, domination, not only of policies, but also business practices to the effect that the subsidiary appears to have no separate mind or will of its own. Okay. Let's take recent cases illustrating piercing the veil, separate juridical personality concept. In the case of Marikalung Mining, so the assets were transferred to G Holdings. Later on, there were workers retrenched years later on. And these retrenched workers would like to collect from G Holdings kasi wala na yung Marikalung Mining assets eh. So, will the veil of corporate fiction be pierced? Does it mean that because the assets were transferred automatically, the liabilities of the transfer will go to the transferee? Well, no, there's no showing that the disposal was made in order to perpetrate fraud. So, the piercing the veil concept was not applied here. What was applied is the separate juridical personality concept. There's also one recent case, the case of Disolgon versus CyberOne, which is about CyberOne Australia. And later on, there is a CyberOne Philippines Incorporated, which was where the stockholders are former employees of CyberOne Australia. So when these employees became part of the corporation, being stockholders, they were retrenched after a few years, and they're asking now for separation pay, not from CyberOne Philippines, but from CyberOne Australia. So will there be liability for CyberOne Australia? Again, the answer is there's no need to pierce the veil. Why? There's no showing again that the creation of CyberOne Philippines was made to perpetrate fraud. Just because majority of the stocks of CyberOne Philippines is owned by CyberOne Australia does not mean that they are just one and the same. Okay, so there's no proof that there was perpetration of fraud. You can see also the slide I'll give to you, the case of Linden Sweets, which is an attempt of Linden to examine the assets of judgment debtor Meridian in order to know how much is their assets and income, because they would like to satisfy certain indebtedness. But this could not be done because the objective here was to ascertain the properties and income which can be subjected to execution and nothing else more. So there will be a fishing expedition which is not allowed here. There is one case which I've been waiting for quite some time. What is this? This is about the reverse piercing. Kasi di ba lagi nating Supreme Court cases ay pierce and reveal? There is no reverse piercing yet. This is the case that I've been waiting for quite some time. Ano ba yung reverse piercing? In reverse piercing, the plaintiff wants to go to the assets of the corporation in order to satisfy claims against a certain insider. So, in reverse piercing, you make the corporation liable for the indebtedness of the stockholders. And reverse piercing can be of two kinds, outside and inside. Pag outside, there's a third party who goes after the individual and wants to be repaid with assets of the corporation. In case of insider, the controlling members would like to ignore the corporate fiction because they want to take advantage which is available to them, like interest in a lawsuit or protection of personal assets. Okay. In the landmark case of International Academy versus Lytton, what was applied here was reverse piercing. Bakit? Santos here owns International Academy. He's making himself, presenting himself as an alter ego of the corporation. That is why when Santos was not able to pay an indebtedness, the creditors went after the corporation where he is president. How come it was allowed? Because of Santos' representation. He's making it appear that he and the corporation are one and the same. Moreover, this indebtedness was incurred even before the creation of the corporation. So, this is the only case, Supreme Court case, on reverse piercing. Watch out for this. Okay? Now, insofar as shares are concerned, okay, there are different kinds of shares. Voting and non-voting. Question, pag sinabi bang non-voting, does it mean that you will not vote as a stockholder because you are non-voting shareholder? For example, preferred, di ba? Preferred non-voting. If you're a preferred stockholder, will you vote? General rule, you cannot vote, but can only vote in certain instances. And in certain instances, I have an acronym for this, esteemed. Okay. Again, hindi na usong bar exam na nagpapadong na enumerate. So, how will this question then be asked? Okay. I'll give you this. Jollibee Foods Corporation. Okay. Jollibee Foods Corporation is, of course, engaged in the food business. Now, you are a preferred, non-voting stockholder of Jollibee Foods Corporation. Nalaman mo na Jollibee Foods Corporation pala ay gusto mag-venture into another business at pagbobotohan daw. Okay. Nalaman mo, it will be Jollibee, JFC pa rin, Jollibee Funeral Company. Okay. You are a preferred stockholder. Ayaw mo magkaroon ng Jollibee Funeral Company aside from the Jollibee Foods Corporation. Can you vote? Eh, non-voting ka? The answer is yes. Bakit? May acronym is SIMIT. Where is that? Amendment of the Articles. Amendment of Bylaws. Sale, lease, exchange, market, pledge of all or substantially of corporate assets. Increasing the bond indebtedness. Decrease capital stock. Merger consolidation. I, investment of corporate funds in other business. And D is dissolution of the corporation. So, nasaan yung sinabi ko sa ASIMID? Sa ASIMID, boboto ka. Alin ka doon? Doon sa amendment. Because that is a different line of business. It will also fall probably under investment in another business, which is also found in ASIMID. So, tandaan nyo yung by heart yung ASIMID, okay? Kanya-kanya tayong acronym sa buhay. Sa akin, ito yun, ha? Kayo, bahala kayo gumawa na sa inyo kasi I still believe in use of acronyms kasi yung brains natin wired na in a sense na pag merong na-touch dito, tatalon siya sa sunod. Eh kung wala ka siyang matatouch, di walang matatalunan. So make use of your own acronyms. Okay. Now, ano bang doctrine na importante sa corporation law? Tandaan, pre-week to ha, hindi lahat ng bagay di-discuss dito. Tigko-konti lang sa bawat isa. Yung what I feel as a 20-year professor is important. Okay. The doctrine of apparent authority. What does this doctrine mean? It's also known as holding out theory or the doctrine of ostensible agency. It simply means that the corporation will be stopped from denying the authority of the agent if it knowingly permits his agent to act within the scope of an apparent authority. And how will you see apparent authority? You will see it in how the corporation holds out this officer. You also see it with its approval with the acts of a certain officer. So, there's one new case, the case of Allied Bank versus Macam, illustrating this. Okay, this is the story. Pasensya na, mahilig ako magkwento kasi this is the only way that you will remember the case. So, may isang bangko, Allied Bank. Yung branch manager, meron siyang valued client. Sabi ng valued client, pwede bang magpa-transfer ng funds to these 5 accounts pero hintayin natin yung pera ko. So, dahil valued client, pinayagan ng branch manager. Turned out, hindi dumating yung pera. Pero napasukan na yung 5 accounts requested and the accounts were withdrawn. Now, can the bank then be held liable for the actuation of its manager? Well, the answer is yes, because applying the doctrine of apparent authority, there was the practice of the branch manager in the past to give credit accommodation or a loan via temporary overdraft to the customer. So this time, the bank cannot say that there is no apparent authority given. It is seen from practice. Okay? In the case naman of Agro versus Vitarich, between these two corporations, they agreed pursuant to a memorandum of agreement regarding buying of chickens and payment of toll for dressing the chicken. Now, this agreement is embodied in writing, MOA. However, there were changes made in the agreement, which is only verbal, among the managers of these two corporations. And this verbal agreement is the one which was implemented. In effect, it changed the written agreement. Now, it's only after 2 years that Vitarich lodged a complaint against Agro about the toll fees. However, there were already numerous contracts which came in, or numerous deliveries which came in for the past 2 years. Now, what should we then follow? Will it be the written contract or the agreement of the parties verbally, which was implemented? Well, again, what was applied here is the doctrine of apparent authority. Why? Because of the conduct. It's 2 years, many 89 billings, several amendments. There was no contest regarding the toll fees. So there was also receipt of the benefits. Receipt of the benefits? The amount paid, there's a price difference, increased. So the acceptance of benefit is also proof of approval with the acts of the manager, even if that is only verbal and not in writing. Okay? Now, how about the doctrine of corporate opportunity? Ano ibig sabihin ng doctrine of corporate opportunity? By the way, nagsisimba ba kayo? O sa mga magbabar, ngayon ang panahon na napaka-religyoso nyo dapat. Okay? So, there's a biblical basis for the doctrine of corporate opportunity. Ang yun. Matthew chapter 6, verse 24. O, di ba? May natutunan kayo sa akin, hindi lang law, pati relihiyon. Ano nakalagay doon sa Matthew chapter 6, verse 24? Hindi let there be light. Ano yun? A man cannot serve 2 masters at the same time. Yan yung doctrine of corporate opportunity. So, if there is a opportunity presented to corporate officers, the corporate officer should not take it for himself. Okay? And kaya nga, it's an opportunity which should belong to the corporation. So, general rule, there would be liability imposed on this officer because that is considered disloyalty. There is a landmark case. The landmark case of Tapros versus Chang. Okay. What is the story of Tapros versus Chang, which illustrated the doctrine of corporate opportunity? Okay. Chang was elected as president and general manager of Tapros. Now, Tapros was engaged in the distribution of office equipment. Chang, however, formed corporations which are also engaged in the same line of business of Tapros. This appears to be with the knowledge and tolerance of the T family. But it's not enough. Just because there was knowledge of the T family, is that enough? There are 4 elements of the doctrine of corporate opportunity. First, must be financially able to exploit the opportunity. It is within the same line of business. The corporation has an interest or expectancy. And when the officer took it for his own, he was placed in a position inimical to his duties in the corporation. So, to determine whether they are in the same line of business, you have to look at whether they are shown to be in competition. Same areas, same products, overlapping markets. Okay. Here, ano nangyari? Sinabi ko kanina, they're both engaged in the same line of business. So, with the knowledge then, is that enough? With the knowledge then of top loss, is that enough? The law requires, the definition yan, that there should be ratification by 2/3 of the outstanding capital stock. So mere knowledge is not enough. Here, there was no ratification. Okay. Now, let's go naman to the requirements of Doctrine of Corporate Opportunity. Kung tanong sa bar, itong top loss case na ito, obvious ang sagot. Kasi pareho silang office equipment distribution. Paano kung baguhin natin? Like, say, restaurant, fast food versus fine dining. Applying the Doctrine of Corporate Opportunity. Example, you are a top officer of a fast food business here in the Philippines. Here in Manila, fast food. Later on, you decided to have a fast food chain also, or restaurant in, say, Cebu. However, the business in which you are an officer is in Manila. And now you'll be establishing one in Cebu. Question, will the valid Doctrine of Corporate Opportunity? Kasi pareho naman kayong fast food, yung corporation na kung saan ka officer. In the 4 elements that you can see, you'll be able to see in the slide, there's a requirement that aside from within the line of business, the corporation must be financially able to exploit the opportunity. So, if there's proof that corporation can venture even outside Manila to expand, then you can apply that doctrine. Okay. Pero paano kung ibahin naman natin? Say, another twist to the same problem, kasi baka ganun gawin sa bar. Paano kung instead of a fast food chain in Cebu, you establish a restaurant, but this time fine dining, here also in Manila. Tapos ikaw naman ay at the same time, top officer ng restaurant na fast food. Fast food versus fine dining. Will there be a violation? Well, again, you have to look at financially able to exploit the opportunity. Why? Are they in competition? Is a fast food chain selling 100 peso meal will be in competition with a restaurant, fine dining, selling a minimum of 1,500 peso per plate? I don't think so. So, ganun yung possible application ng Doctrine of Corporate Opportunity. Okay? Now, for liability of the Board of Directors, Trust and Officers, we follow a certain rule. What do we call that rule? Business judgment rule. So, questions of policy and management are left to the decision of the officers. So, there will be no responsibility or liability for a wrong decision unless it was made in bad faith, unless there's gross negligence. Let's take an example. Supposing the officer made a wrong business forecast, resulting to a loss on the part of the corporation. Does it mean that there will be personal liability on the part of the officer? The requirement is there must be showing of bad faith. There must be showing of gross negligence. So if the negligence is just ordinary in character, not gross, then there will be no personal liability. Okay, so the requirements, aside from allegation to complaint, there must be proof of bad faith or gross negligence. And bad faith is not assumed. Okay? It means dishonest purpose. It must mean fraud. Okay? Now, let's take again an example about that. In the case of Malate versus extraordinary realty agents, the president of the corporation was sued together with the corporation, where he is an officer because there was not payment of commission to an agent. Should there be solidarity liability on the part of the corporate officer? So what are the requirements for solidarity liability? So under express provision of the law, when the directors or trustees or officers vote or assent to patently unlawful acts, guilt of bad faith, conflict of interest, issuance of watered stock, ano ba yung watered stock? Issuance of stock for less than adequate consideration. So kung piso per share, hindi ka dapat magbenta ng 50 centimos. Or when the director or trustee has contractually agreed to be solidarily liable with the corporation, like signing as surety together with the corporation. Or when there's specific provision of law making a corporate officer person liable. Example doon, in BP 22, express provision of the Bounce and Checks law. The officer who signed there will also be personally liable. Okay. Now, here, in this case of Malate, there was no showing that these requirements were complied with. It was not shown to be patent unlawful or bad faith or gross negligence. So it's not a personal liability of the corporate officer. Okay. Now let's go to the next topic in Corpo about corporate powers. After isa din to the favorite source ng bar exam questions regarding specific powers. Kasi, di ba, our corporation exercises general, specific, express, implied powers as including incidental. Pero paborito tanong sa bar is specific powers. Okay, let's go with the items one by one. The first one would be extension or shortening the term. Pag tinanong ang powers, ang normal na follow-up dyan ay appraisal right, tsaka votation. Who votes if the term is shortened or extended? It's the BOD, Board of Directors, Board of Trustees, plus 2/3 stockholders, outstanding capital stock. What about appraisal right? Appraisal right is the right of a dissenting stockholder to be paid for the fair value of his shares if he dissents with particular corporate acts. So, if the term is changed, appraisal right is present. Why? Because there will be a change in the principal contract with the corporation. So, anong principal change? Because when the term is shortened or extended, for example, the term is short from 50, it becomes 20. The stockholder then is deprived of his right to earn future dividends. On the part naman of extending, if its a term is 50 to 100 years or in perpetuity, which is already the new corporate term, anong right ng stockholder affected? Well, he is deprived of the right to expect the return or return of the fair value of his investments because he should be given a share of the assets upon liquidation, and liquidation will not happen in his lifetime kasi nga forever yung new term. Diba? So that's how it is being asked. What else? Power to increase or decrease bond indebtedness, power to increase, decrease capital stock, same votation, but this time no appraisal right. Bakit walang appraisal right kapag hindi ka pumayag na yung corporation ay mag-increase or decrease your capital stock? Because their logic for the issuance will come to naught. Bakit? Why would a corporation issue capital stock? Why would a corporation issue bonds? Because it needs funds, di ba? And if it will allow a dissenting stockholder to exercise appraisal right, then the money generated from the sale of stock, sale of bonds, will just be used to pay off a dissenting stockholder. Kaya walang appraisal right. Okay? Now, anong function ng SEC if a corporation would apply for an increase or decrease in capital stock? The SEC's job is only ministerial. It will just have to look at whether this complies with all the requirements. It cannot question the wisdom behind. Bakit? Don't forget the BJ rule. Okay? Business judgment rule. Ibang BJ nasa isip nyo, no? Okay. Next is the power to deny preemptive right. Ano yung preemptive right? It is the right to subscribe to all issues or disposition of shares of any class, proportionately. And this right will be enjoyed by stockholders unless it is denied by the articles. But that preemptive right will extend to circumstances like there are shares to be issued in compliance with law regarding stock offerings or minimum stock ownership, or the shares are to be issued in good faith with approval of the 2/3 of the outstanding capital stock and used for property needed for corporate purposes or payment of a previously contracted debt. Previous debt hindi future debt ang requirement here. When we say issuance, there's no distinction whether that is treasury, that is coming from the old, coming from the new, basta issuance or dispositions. The fourth one would be sale or disposal of assets. And the voting requirements is the same. Majority, board, plus 2/3 stockholders. But this automatically means that there's always stockholder action. It depends. If that is the usual and regular course of the business of the corporation, stockholders will not vote. Or the proceeds of the sale will be appropriated for the conduct of the remaining business. Let's take an example. The nature of the business is selling condominium units. So, majority of the assets, of course, would be condominium units because that is the one that's made the principal business. If the corporation will be selling 99% of its inventory, they don't need stockholder action. Bakit? Because that is the usual course of the business. Pero paano kung manufacturing, tapos ang binenta ay yung mga equipment niya, which is, of course, required in the manufacturing business, then that would require stockholder action because that is not the regular course of the business. However, there is an exception. If the proceeds of the sale will be appropriated for the conduct of the remaining business, then you don't need stockholder action. Meaning, let's take again that example. A hotel which has a transportation department as well as a housekeeping department. So the transportation department is dissolved and all of the cars were sold. So if the proceeds of the sale will just be infused to the remaining business, so it will be infused to the housekeeping department, then you don't need stockholder action. So, how will you know then if it is all or substantially all of corporate assets? Kasi wala namang sinasabi ang batas, ang number, how many percent. There is, however, a formula. It is based on the net asset value as shown by the FS, financial statements, or if the corporation will be rendered incapable of continuing the business or accomplishing the purpose for which it was incorporated. Example again, there is one Supreme Court case about a transportation company which has a repairs department. The repairs department was sold. The assets of that repairs department sold off. So does it require stockholder action? Is that all or substantially all? The answer is no. Why? Because even if the repairs department will be sold, what will happen to the transportation business? It can still continue even if there's no repairs because repairs can be outsourced. So the requirement is if the corporation will be rendered incapable of continuing the business. So transportation business can still proceed even if there is no repair section. Let naman sa bar ang the Nel Doctrine, which is the Y.I. Leisure case. Ano ba itong Nel Doctrine? Ang sabi ng Nel Doctrine, transfer of assets from transferor to transferee will make the transferee liable for the indebtedness of the transferor, except in 4 instances. Ano yun? First, there is agreement to assume these debts, or that is a merger or consolidation, or that is entered into for purposes of fraud to escape liability. And the fourth one would be if the purchasing corporation is merely a continuation of the selling corporation. Let's go back to the case of Y.I. Leisure. The assets of Y.I. Leisure, were all infused to 3 other corporations. So James Yu, who purchased Country Club shares from Mount Arayat Development, was not able to get back his investment kasi non-existing yung club and the assets were transferred by Mount Arayat to 3 other companies. So, can James Yu then go after these assets which are already with the 3 other entities? What that Supreme Court applied here is the third one. The transaction or transfers entered into fraudulently to escape liability. Okay? So, when this Nel Doctrine is asked again, do not never think that it will be asked via enumeration. It's via application. Okay. Next would be the power to acquire own shares. Anong tawag doon? Treasury shares. But there must be URE. Anong URE? Unrestricted retained earnings. Why would a corporation buy back its own shares? Di ba parang illogical? A corporation would sell. But why would it buy back? Because there are reasons. First, to eliminate fractional shares arising out of stock dividend. Example, you have 1 share of stock. Pag nag-declare ng 10% stock dividend, ilan ang shares mo? 1.10. So, Para matanggal si 0.10, ang tawag doon, magiging treasury shares. Okay. What else? Compromise unpaid subscription. So delinquency sale. A stockholder who fails to pay his investment will be considered a delinquent one, and this can be bought back. This unpaid subscription will be bought back by the corporation if the corporation has URE, or the stockholder exercised his appraisal right, meaning he dissented. Bakit kasi may URE lagi? Unrestricted earnings. Anong doctrine ang kakambal niyan? Trust fund doctrine. Why? Under the trust fund doctrine, the creditors are looking after these capitals of the corporation. So this cannot be touched. This cannot be used to pay off anyone except the creditors. So if there will be payment to stockholders via delinquency sale, then there must be URE always. Next would be power to invest. I've said earlier, if that is the primary purpose, you don't need stockholder action, only board approval. But other than primary, you need stockholder action. So, 2/3 vote pa rin ang requirement, appraisal right pa rin is present. What else? Power to declare dividends. Pareho lang ba ang dividends tsaka income? No. Why? Must there always be dividends? Dividend is subject to the business judgment rule. A corporation can earn income, but it does not mean that it will be distributed to the stockholders via dividends. And the law requires, however, further votation requirement for cash dividend, majority of the board, for stock dividend, board plus 2/3 of the standing capital stock. Assuming the corporation has a paid-in capital of 10 million, the corporation earned 5 million. Is the corporation compelled to issue dividends? Kasi may 5 million. The answer is no. Why? Because stock corporations can retain surplus profits up to 100%. Pero pag lumampas na 100%, this time, they're required to issue dividends. But again, there's an exception, meaning the corp, even if it goes beyond 100%, but they are retaining the surplus for certain reasons, like corporate expansion projects, which is approved by the board, or prohibited under loan agreement, where you have to get the consent of the creditor, or if the retention is necessary, like there is a special reserve for probable contingencies. Paano ito sa bar before? Asian financial crisis, or pwedeng tanong, COVID pandemic, kaya hindi sila mag-issue ng dividends because they need the money for reserve. Is dividend the same as profits? I said earlier, profits belong to the corporation, dividends belong to the stockholder. And it's possible, therefore, that there is profit, but there will be no dividends. Paano naman kung, say, ang value ng lupa noon per books ay 1 million pesos. Ngayon, 10 million pesos na. Pwede bang mag-declare ng dividends sa 10 minus 1 equals 9? The answer is no. Why? Because it was not yet realized. You can only declare it once you have sold the property, and then the price difference then would fall under retained earnings. Okay? So it can be a source. Paano naman kung say the capital stock par value is 1 peso per share. Nabenta mo ng 5 piso. Di ba may kita ang corporation ng 4 pesos? Pwede bang yung gawin na dividends? The answer is that item, that 4 pesos is called paid in capital, paid in surplus. That can be a source of stock dividend, but never cash dividend. Okay? So sa mga accountants, alam ko nagkakaintindihan tayo ng pinagsasabi kong hayop. Ang alam ko yung iba ay nag-imagine ano yan, basta. Now what else? The power to enter into management contract. So this time the voting is lower. Majority lang ng board plus majority of the stockholders, but there's a special ratification rule of 2/3 if there is commonality. Meaning the stockholders represent the same interest in both the manage, own or control more than 1/3, and majority of the board of the managing is also majority of the board of the managed. Okay. Now, let's apply regarding the powers. Let's apply a certain case, the case of Salido. Anong kwento nito? Si San Juan may investment sa as stockholders ng corporation. 55% ang kanyang ownership. Pero hindi siya nakabayad. Therefore, as sinabi ng corporation, ibaba na lang kasi hindi nagbayad. Gawin na natin treasury shares na hindi bayad from 55 to 15%. Tama ba yun? The answer is no. Remember, there should always be unrestricted retained earnings. Here, the corporation is new, so there is no URE. So what should be the remedy? If it was not paid, it's via holding of a delinquency seal. Because if you would simply agree that the unpaid subscription be converted to treasury shares, it will violate what doctrine again? Trust fund doctrine. Because it is earmarked for the creditors. Now, let's go to merger and consolidation. I know there is a technical definition regarding merger and consolidation. Because in merger, one corporation absorbs one or more. And the absorbing corporation survives. Okay. In consolidated, two or more form a new corporation called the consolidated. But whether that is merger or consolidation, pareho lang. Bakit pareho lang? Pareho lang ang effects. The one who survived or the consolidated corporation will assume automatically all the assets and liabilities and they would then continue the business. So magkaiba lang sila ng term, pareho lang ng effect. Okay? So I said that there's automatic assumption of all the assets and liabilities. There is one case, the case of Philippine geothermal. Dahil meron ng merger, ang Unocal, Blue Merger, and Chevron. So may mga empleyado natanggal. Now, these employees, through the union, wrote Unocal asking for separation pay. Now, is the corporation bound to pay separation pay? The answer is no. Why? Kasi sabi ko lang, what happens in merger and consolidation? Absorb. All the contracts absorb, including employment contracts. Therefore, there's no obligation to pay separation pay. However, kung isipin nyo, di ba kaya naman sila natanggal kasi nagkaroon ng redundancy? The removal, they were removed by redundancy. Pero, kaya nagka-redundancy dahil nagkaroon ng merger. Kaso na tayo magagawa. Sinabi sa Supreme Court, well, the cause for the removal is pursuant to the labor code provision of redundancy and not just because of a merger. Pero, di ba kung di naman nag-merger, di ba hindi magre-redundancy? Parang ang proximate cause pa rin in merger. Ano tayo magagawa? Yun ang sabi ng Supreme Court. Prove lang tayo. Maghintay lang tayo ng bagong jurisprudence just in case. Okay. Now, what else? There's one new case, the Paranaque Industry Owners Association versus Resyo. Anong kwento nito? This association owns a parcel of land. However, the certificate of registration was revoked. And later on, tinamad yung old board. Hindi sila nag-liquidate. Ang ginawa nila to simplify, inire-register na lang nila yung luma using used another name, adding incorporated to the name. Okay. So a new certificate was issued. Now, remember that this is an old corporation and it has already assets. One of its land was illegally occupied. So, ang nag-file ngayon ng suit ay new corporation. Will this suit prosper? The answer is no. Why no? Because remember, this corporation is already defunct. So there is no more right to sue. Why? There's only a 3-year winding up period. It did not do so. It did not formally liquidate. What it did is just to re-register. But the re-registrations would have an effect. Anong effect? It would be already a separate and distinct entity from the old. It did not assume the assets of the old. Therefore, the case for ejectment cannot prosper because it was filed by the new corporation. Okay. Now, how about on doing business? On doing business, it's you just look at the provision of doing business only if a foreign corporation the foreign corporation must secure a license if it will do business. So if it will not do business, it does not need any license, diba? And what is doing business? So the true test of whether it is doing business or not is whether the foreign continues the body or substance of the business for the enterprise for which it is organized, or there's a continuity of commercial dealings. And there are cases illustrating continuity. Okay? Paano kung ginawa ng corporation, halimbawa, foreign corporation, nag-invest dito sa Pilipinas, bumili ng shares of stock, and then received dividends. Later on, may tax refund ang kiniklaim ng corporation. Kailangan pa ba niyang kumuha na license to business just to pursue the case for tax refund? The answer is no. Because doing business, there's an enumeration for under the law, excludes mere investment. So if there's a just mere investment of stockholder by a foreign entity and domestic corporation, that is not doing business. Okay? Even if it derives income. Now, I recall again the Magna Ready-Mix Concrete because this is a landmark case on doing business. Kasi di ba sabi ko kanina, continuity. So ibig sabihin, hindi lang isa. Dapat maraming kontrata because that is continuity. But the Magna Ready-Mix Concrete qualified that. Even if it is just a single transaction that can constitute doing business. How come? Because in Magna case, Magna, the Philippine corporation, ordered from a U.S. corporation the form, design, and drawing development of a project. And that name of corporation is Andersen. Now, when Magna did not pay, Andersen sued the Philippine corporation, but the Philippine corporation said, hoy, wala kang license to do business. So, tama nga ba na there must be a license to do business? Well, even if it is just a single contract, the Supreme Court said, yes, that there is a requirement to get a license to do business because even it was just one transaction, it was in progressive pursuit of its business purpose. Why? Because its job is consultation and design service. That is its main business. So a single act can be doing business when the corporation performs acts for which it was created or exercise the functions for one in which it was organized. So, it becomes isolated if it is different. Pero same lang eh. Kaya, kahit isang kontrata lang, it is doing business. However, hindi ito nagamit na argument ng Magna. Bakit? Yung in-apply ng Supreme Court ay estupel. Because when Magna enters into contract with Andersen, it is now stopped from challenging the legal capacity. Pero explain lang ng Supreme Court, ano yung doing business? Pero hindi naman yun nasagot. Dito, hindi na i-apply. Okay? Now, what if a contract was entered into where the foreign corporation passes through a middleman? Does it mean that the foreign corporation, which passes through a middleman, must get a license to business? This was answered in the case of Development Bank versus Monsanto. If the foreign firm does business through the middleman, and the middleman acts in its own name, they are called indentors. They are commercial brokers or commission merchants. The foreign firm is not doing business because the one who's doing the business is the middleman. So there's no requirement to get a license to do business on the part of the foreign corporation. Now, let's go to the last topic here is on derivative suit. There are basically three kinds of suit depending on who is the aggrieved party. It can either be an individual or class suit or a derivative suit. When you say individual suit, the cause of action belongs to a particular individual, like there was a refusal for the examination of corporate records. For a class suit, meaning a particular group is wrong, like the group of common stockholders. But in derivative suit, the one who's wrong is the corporation. But if the one who committed the wrongdoing is the board of directors, then who will sue in behalf of the corporation? Kaya, derivative suit is applied here. So, what then are the requirements for a derivative suit to prosper? Under the rules, first, the persons instituting the suit must be a stockholder or member at the time of the transaction and the time of the filing of the action. There must be exertion of all reasonable efforts as outlined in the articles or bylaws, no appraisal right is available, not a nuisance or harassment suit, and it must be in the name of the corporation. Okay. Let's take a look at how this is being asked. Again, I'm highlighting a landmark case, the case of Ago Realty. Okay. In Ago Realty, ang story is simple. There is a corporation where the stockholders are all siblings. Now, the elder sister decided to make changes in a corporate property. That sister owns only 30% of the shares. Majority, 70%, owned by Emmanuel. Now, ang ginawa ni na Emmanuel, who owns 70% of the shares, they filed a derivative suit. Is that correct? The use of a derivative suit by the majority of the stockholders. Remember, before instituting derivative suit, there must be exertion of all reasonable efforts. So exertion of all remedies available. And there's no showing that all efforts were exerted. They just said that nag-walk out ng kapatid namin, that is not enough to say that there is exertion of all reasonable efforts. Also, the majority cannot use a derivative suit. Why? Because when the majority is wronged, board-sanctioned litigation will take precedence over derivative acts. Because you are the majority, you can just simply oust the minority via your vote. But the problem is this could not be done by Emmanuel because they did not formally organize a board of directors. So the failure of the constitutional board of directors should not be used by Ago to their benefit. Okay, so the failure to institute resulted to failure to exhaust all legal remedies available. So he's not allowed then to institute derivative suit to shortcut the provisions of the law. Diba? Kawawa. Kaso balik. Hindi niya siya na-organize. Now, what if in a derivative suit, the complaint did not say that there are no appraisal rights available? There was also no sentence saying that this case is not a nuisance or harassment suit. Will the case fly? The answer is no. Because the suit must particularly allege that there is no appraisal right. That this is not a nuisance or harassment suit. Look, the law only asks you to allege, not to prove. There are two different things. So even if it was not proven later or is immaterial, what the law only asks you is to allege, meaning to put into writing that this is that's not a harassment suit, that there's no appraisal right available. Proof is another thing. Okay, so let's go now to partnerships. Alam niyo yung partnership, parang yung pamilya, merong isang paboritong anak sa bar examination, ganun din. Ang partnership ay hindi paboritong anak. Pero syempre, anak pa rin yan, kaya aaralin natin, okay? So, ano tinatawag sa partnership? So, the definition. So, contract of partnership, two or more persons by themselves who contribute money, property, and distribute a common fund with the intention of dividing the profits among themselves. So, hindi naman tinatanong sa bar ever define partnership mo. Again, ina-apply yan through rules. How would you know that there is a partnership or not? Using the elements as defined. Okay? First, if you are not parties to one another, then you're not parties to other persons. Okay? To third persons. Co-ownership does not mean that there is a partnership. If you share gross returns, that's not enough evidence of a partnership. If you receive money, that is a prima facie evidence of being a partner in that business. Except if that was payment because of a debt, or wages, salary, annuity, interest na loan, or consideration for the sale of a goodwill of a business or other property. But if you demand periodic accounting, then that's evidence of partnership. let's take one case, the case of Santiago versus Paulo Garcia. So, nag-invest si Marian kay Edna where there should be a return of 5 to 8% per month. However, Edna defaulted. So, Edna was sued. Pero anong argument Edna? Hey, I am industrial, si Marian capitalist. However, there's no contract presented. Is that a partnership? The answer is no. Estafa nga yun actually. So, partnership is a result of an agreement. Here, there was no allegation or proof that they agreed to enter into a partnership. What was presented only is the agreement that this person will receive monthly interest. So, receipt of money, share the profits, is not a conclusive proof that there is a partnership. Now, this is one case, Justice Lopez case. Bihira lang Justice Lopez kaya ngayon na-highlight ko. Justice Lopez case ito, Dusol versus Lasso. So may mag-asawa, caretakers ng beach resort. So tumatanggap sila ng monthly pay. However, the resort was leased out. They lost their job later on. Thus, they filed a complaint for illegal dismissal. Pero sabi ng owner ng resort, teka, yung mag-asawa, industrial partner. Ako yung may-ari ng resort, pero may partnership kami. Yung mag-asawa, industrial. Ako yung capitalist. Tama ba yun? Again, no. Why? No documentary evidence was submitted. The only evidence was the statement of the resort owner. And the couple did not receive wages, but merely allowances or commission is only based on the statement. So again, receipt of money is not enough to show that there is a partnership. There's also no intention to divide the profits. Wala namang computation on how the income of the resort is to be divided. So how will you know that it's indeed a partnership? Again, the couple are considered to be employees. Thus, they should be paid for their dismissal. Okay? Now, what will be the rules on the management of a partnership? The one who should manage should be the managing partner, if there's a managing partner. But if there's not, then all the partners are presumed to act, okay, in behalf of the partnership. Pero paano kung mayroong managing partner? And there will be a decision. Of course, the decision of the managing partner will prevail. But what if there will be a tie? Okay, who will prevail? Whose decision will prevail? It's the decision of the one who has the controlling shares. So, example, dalawang industrial partner, there are two capitalist partner, and among these four, dalawa dito yung managing partner. Pero these two managing partners are not in unison insofar as the person to be, so far as a certain policy is concerned on who is to be hired. Then the one who should decide will be, because of the tie, will be the other partner who have the controlling interest. So, you will have to look at the amount of investment that they make. So, ganyan yan din sa bank before. You have to look at the amount. The one who contributed the biggest amount will have the same. Okay. Now, another instance, paano ito tinatanong? You see there in the slide, there's a partnership between 5 persons. There are 3 capitalists, Goku, Gohan, Chichi. Then there is a limited partner, Mr. Pogi, and there's Vegeta, the industrial partner, contributing services. Now, in the articles, Goku and Mr. Pogi is managing. Goku's liability is only to the extent of his capital, and Vegeta is not liable for the losses. How will you compute income? How will you compute distribution in case there's profit or there's loss? What you will do is proportionate. So in this instance, if the partnership had an income or profit of 800,000, how will you compute? Alam nyo, alam ko nung marinig ko ngayon, sinasabi nyo, kaya nga ako nag-law, ayaw ko ng math. Punyeta kayo, diyan kayo nagkakamali. Merong math sa law. Lahat, transpo, corpo. Kahit sa insurance, makikita nyo, may math pa rin doon. Akala nyo mapagtataguan yung math. Hindi. So ngayon, eto, tinanong to, 800, how would you distribute? 100 is the fair share of the industrial. Paano 700? Ratio and proportion. Nakita niyo yan? 1 is to 1 is to 1 is to 2. So 700, i-divide mo by 5. So 140 per share. So if Mr. Pogi has 2 shares, 280. So, teka, kilala niyo ba characters na ito? Hindi siya. O, i-research nyo. Hindi yan. Now, what if the creditors agreed that Goku and Mr. Pogi and Vegeta, if the creditors hold Goku, Mr. Pogi, and Vegeta liable, even if there's agreement between these three insofar as their liability, creditors can go after them. Why? This stipulation, exempting Vegeta from losses, is valid only among the partners. So, there will then be a recourse. If there will be a recovery against Vegeta, Vegeta can go after the rest of his partners. But for creditors, they can go after Vegeta. Now, insofar as Mr. Pogi is concerned, di ba sa story si Mr. Pogi, limited partner? Di ba limited partner is similar to a capitalist is only liable up to his investment? But in the story that's given here, the limited partner took part in the management. So now, he becomes a capitalist partner. Okay, so there will be liability. Ano pa tinatanong sa bar partnership? Again, tungkol sa running, how the partnership is being run. Okay. Erica and Richard agreed to operate a car wash. Si kay Erica ang capital, kay Richard ang industry. Now, Erica opened a coffee shop. Richard set up a car accessories. Can they engage in separate businesses? Remember that they are partners. If you are a capitalist, you can engage in a business as long as it is not in the same kind. So here si Erica ay coffee shop. Hindi naman yan same line of business na car wash. So pwede. However, Richard, who is an industrial partner, cannot set up business. Why? If you are industrial, you are required to devote your full time. So, hindi ka pwede kahit pa hindi in competition yung business mo. Okay? Now, paano naman mo ganito? So, si Erica and Richard pa rin. May dinagdag sila, isa pang tao. Now, itong tao itong dinagdag, sa kanya inassign yung interest. Is the assignee then entitled to interfere in the management and inspect the records of the business? The answer is no. Why? If the interest is transferred from the partner to the assignee, the right of the assignee is only to receive the profits. He has no right to inspect the records. He is not made a partner when the interest is assigned. Why? May Latin term yan sa partnership, delectus personae. Kaya hindi pwede. Okay? So what he will only receive would be the share of the profits, but no right to examine. He cannot exercise the right of a partner. Okay? Yun lang ang importante sa partnership. So let's go now to insurance law. Again, yung definition ng insurance, pag tinignan nyo sa code, ay hindi siya tinatanong in the form of enumerate the elements of an insurance contract, hindi sa ganung klaseng definition type, kundi application. Okay? So, in a contract of insurance, there's an agreement whereby one undertakes for consideration to identify another against LBL, loss, damage, or liability arising from an unknown or contingent event. So, if you act as insurer, you act as surety, do an insurance, do anything of the foregoing, that is also considered to be doing insurance. If there's no profit derived, that's immaterial in the definition of an insurance. So, as regards the nature and characteristics of an insurance contract, meron tayong bagong case. The case of Eastern Overseas versus Heirs of Odulio, which highlighted anong pinagkaiba if you're agency hired versus direct hired. If you are agency hired, insurance is compulsory. But if you are direct hire, name hired or rehired as defined by labor code, it is not mandatory. Okay? Take note regarding mandatoriness of insurances. Now, paano naman kung, say, mag-asawa, they mortgage a conjugal property and then MRI was taken? Ano bang MRI? Mortgage Redemption Insurance. ang kumuha ng MRI yung babae lang. So, what then will happen if the one who died is the husband? Remember, an MRI is a device where in case of the death of the mortgagor, the proceeds will be applied for the debt. But the one who took the insurance here is the wife, and the one who died is the husband. Even if the party involves conjugal property, this because the husband is not a party to the MRI, there can be no recovery from the insurance. Ang heart nga pala ng insurance, ang tinatanong lagi, is all about insurable interest. Okay? Parang ito yan pag nagtanong ka sa korpo, anong iniisip mong pwedeng tanong? About powers. Based on statistics, ang karaniwang tinatanong ay powers. Second would be the doctrine of separate judicial personality interest and avail. Pero din, pag nagtanong sa insurance, ang unang-unang tinatanong, it's all about insurable interest. And what is insurable interest? It is that interest in the subject matter, in which will continue to exist if the person are saying, you're deriving pecuniary benefit. But when the person dies, when the thing is lost, you likewise sustain pecuniary loss, then that is insurable interest. Pero yung ganyan definition is not absolutely correct. Why? Because I'll make an illustration again for you to look. Halimbawa, ikaw ang jowa. Okay. Siyempre may pakinabang ka sa jowa mo. Mabait sa'yo, inalagan ka, hindi mo lang siya fubu, marami ka nagagawa. So, kapag namatay yung jowa mo, di ba, apektado ka? So, does it mean that, can you take an insurance on your jowa's life and you are the beneficiary? The answer is no. Because if you will take an insurance on someone else's life, that person must be related to you pursuant to Section 10. Okay? Because if there is no such requirement, kung sasabihin lang natin is just because you're deriving benefit, pwede ka na kung insurance, there will always be the temptation to kill someone for the money. So the law requires, dapat naka-enumerate ka sa Section 10 in life insurance. Saan yun? Okay, let's go now. You see the slide, the distinction between life insurance and property insurance. Pag tinanong sa bar ito, tinatanong rin ang distinguished insurable interest in life versus property. Okay. Kung sakaling tanong yun, ito ang demarcation natin. Insurable interest in life would consist of the second column, you will see that's numeration in Section 10. In property, it could either be existing interest, inchoate interest, or expectancy, the last two being founded or anchored in existing interest. What else is the difference? In life, the beneficiary is anyone. That's why it is revocable. But in property, the beneficiary must possess insurable interest in the subject of the insurance. In life insurance, insurable interest must exist at the time the insurance takes effect, but need not exist thereafter. But in property, there are two periods: at the time insurance takes effect and at the time of loss, but need not exist in the meantime. How much in life insurance? It is unlimited, but in property, it is limited. Okay. Now, let's go zero in on the particulars kasi dyan nagtatanong sa bar. Okay, let's go first with insurable interest over yourself, spouse, and children. You can take an insurance on yourself, no problem. But if you will take an insurance on someone else, he must be related to you. So, you have insurable interest over yourself. Spouse, when the law says spouse, it must be legal spouse. Hindi asawa, jowa, fubu, whatever. Okay? Children, however, this time, the law does not make distinction. It can be legitimate or illegitimate. Now, the second requirement, enumeration, person on whom you depend wholly for education or for support, or on whom you have pecuniary interest. And who are the persons who are obliged to support one another? You go back to your family code, Articles 195 and 196. So parents, sibling, parents and their children, and the legitimate and legitimate children of the latter. So legitimate ascendants and descendants. Basta yung enumeration under the family code, balagan din, ha? How about if you have pecuniary interest arising from employment? Like, this was asked already in the bar. you are an employee, can the corporation take an insurance on your life and designate itself as the beneficiary? The requirement for employment is that not the corporation should be materially injured with the death of the employee. So it's not, you don't look at the title, nomenclature, you look at the function being exercised. Say, in the case of, there's one case actually, landmark case of El Oriente. He is the only one who knows the formulation of the tobacco. So pag namatay siya, babagsak yung tobacco business. So that's why the Supreme Court said, there can be an insurance on the life of this employee. Paano kung katulad ng nakarang bar examination, 2011, ikaw ay may driver, meron kang maid, pwede ka ba kumuha sa insurance ng driver at maid mo at ikaw beneficiary? Sabi mo, babako yung bahay mo, wala magdadrive sa'yo. Pwede ba yun? Hindi ganun kababaw. Dapat material injury. Okay? Now, the third, legal obligation for the payment of money in which death or illness might delay. Ito, binabantayan ko. This is a landmark case of the De La Fuente versus Fortune Life. So, this is the story. So, creditor nag-invest ng 3 million sa lending ni debtor. Si debtor kumuha ng life insurance, 15 million. Ang kanyang beneficiary, si creditor. Yung utang na 3 million ng anak, naging 16 million. Namatay itong si debtor. Now, the policy is 15 million. The debt was 16 million pero nag-partial payment si partner, naging 14 million. So, would the creditor then have insurable interest over the lending and for how much? The insurable interest is the outstanding obligation at the time of loan, not at the time the policy was taken. So, it is up to 15 million but there was partial payment kaya 14 million na lang. Because when the debtor took an insurance, what he's thinking of is that the policy is a collateral for his debt. Okay. Paano ngayon? What if, say, for academic discussion, paano kung na-fully paid na? Wala nang loan si debtor. What then will happen? When the debtor insures his life for the benefit of the creditor and there is full payment, the proceeds will go to the estate of the debtor. So, meron pa rin makaka-recover. Paano naman kung it's the one who took the insurance is a creditor on the life of the debtor? What then will happen? If the loan is fully paid, then no one can recover. The creditor cannot recover anymore because there's no more indebtedness. That is the limit of the interest of the creditor. Now, how about on the part of the debtor? Bakit hindi pwede kumuha ang debtor? Kasi the one who took the insurance is the creditor. There's a difference, ha? Take note of this, De La Fuente case. Okay? Now, let's go back. Legal obligation for the payment of money. And number 4, that would be a case of use of rock. Any person upon whose life and asset or interest vested in depends. Okay? Now, in life insurance, insofar as beneficiary is concerned, the beneficiary is the one who will receive the proceeds. Thus, because insurance in life is based on generosity or liberality, it is revocable. Okay, how is this asked? Ikaw ay merong, kumuha ka, ikaw ay binata, kumuha ka na life insurance. Ang beneficiary mo ay yung nanay mo. Now, nag-asawa ka, dinagdag mo yung asawa mo. Pwede bang umangal yung nanay mo? The answer is no. Why? Because the designation is revocable. The beneficiary is revocable. So, the insured, you can put any beneficiary that you want. You can change the beneficiary. Paano ngayon kung ang ginawa ng nanay mo, siniraan yung asawa mo sa'yo. Sabi niya, hoy, yung asawa mo yan, nanlalalaki yan. So, naniwala ka, tinanggal mo as beneficiary yung asawa mo. Pwede mo umangal yung asawa mo na, hoy, hindi totoo, sinisiraan lang ako ng nanay mo, hindi ako nanlalalaki. Is that enough? The answer is no. It is based on liberality. So even if the basis for the change has no foundation, well, it's immaterial the story. It's based again on liberality. However, if you made the designation irrevocable from the very beginning, the beneficiary acquires vested rights. Meaning you cannot change anymore the designation. You cannot add. You cannot get the cash surrender value. You have no more right over the insurance because it had become irrevocable. But that rule admits of exceptions. What are these? In case of void marriages, of course, even if the guilty spouse is instituted, pero siya ang guilty, matatanggal siya. And what else? If he is the principal, accomplice, or accessory in willfully bringing about the death of the insured. Let's take the example which was asked in the 2008 bar. Okay? Si anak ay ang beneficiary ng insurance ni tatay. So si tatay ay mabait na tatay, kaya dinesignate niya beneficiary si anak na pasaway. Si anak, nag-hire ng killer para patayin si tatay. Now, nagkuwanta ang hired killer na ang mastermind ay si anak. Remember, the insurance was taken by the father with the child as beneficiary. So, can the insurance company deny liability? If that is the phrase of the question, the answer is no, the insurance company cannot deny liability because even if the beneficiary designated is disqualified, the proceeds will go to the other qualified beneficiaries. If there's no other qualified, it will go to the estate. So, laging liable pa rin ang insurance company. Okay? Pero kung tanong ay, can the child get the proceeds? Ang sagot naman dun no. So, because she or he is disqualified. So, take note of how the question is being phrased by the examiner. Okay? Paano naman kung ganito? Ikaw ay beneficiary ng isang life insurance na kinuha ng tatay mo. Naglalakad ka sa gabi, madilim. May sumisit-sit sa'yo. Hindi mo makita, sulakad ka pa ng diretsyo. Now, hinawakan ka sa likod, natakot ka, akala mo hold upper kaya sinapak mo. Yung pala, tatay mo. Natumba, patay. Ikaw beneficiary, can you get the proceeds? The answer is yes. Why? Kasi di ba sabi ko, willfully bringing about the death. Is this willful? Hindi. Accident to, di ba? Yun. Take note again of how the story is being given. Okay? What else? This qualification of beneficiary says anyone can be beneficiary. Okay, except those under Article 739. Sino yun? Persons found guilty of adultery or concubinage, found guilty of the same criminal offense, those made a public officer's wife a senator of the Senate by reason of his office. Among those three, ang paboritong tanong sa bar na 4 na beses tinanong ay yung adultery or concubinage. So the case of Maramag versus Maramag comes to mind. Okay, ito ang kwento. Si tatay, may legal family. So meron din siyang mga anak. Pero, meron siyang kabit. May anak din siya kay kabit. Dahil mahal niya si kabit, kumuha siya ng insurance, designated beneficiary niya ay si kabit at anak niya kay kabit. So, na-dead si tatay. So, itong si legal family, umangat. Sabi nila, hoy, kabit, sabi ng legal wife, yung share mo, dapat ay akin. Tama ba yun? The answer is no. Why? Indeed, the common law, the concubine, is disqualified. However, the illegitimate children are qualified beneficiaries. Therefore, the share of the common law will go to the illegitimate. Sabi naman ng mga legitimate family, oy, mga kapatid sa labas, maghahati tayo kasi, di ba, succession, legitimate is 2:1. Tama ba yun? The answer is no. You cannot apply the rule of succession because there's a special law on the matter, the law on insurance, which allows illegitimates to recover. So, ano nangyari? 0 ang legal family. That's why this Maramag versus Maramag doctrine is being questioned. Why? It's now circumventing the provision on donation because the law on donations prohibit this. But if you will use insurance, pwede pala. Well, what tayong magagawa unless we see later on jurisprudence changing the Maramag versus Maramag doctrine. Paano kung, sige, mamaya, may long chain story ako para maalala nyo. What else? Okay. When should insurable interest exist? At the time the insurance takes effect, no need to exist thereafter. Dito lang tayo titingin. Parang kabayong may piring. In insurable interest in life, you only look at one period. At the time the insurance takes effect. Now, how much? Sabi ko kanina, is unlimited. Why? There's no value for human life. So, as long as you can pay the premiums, pwede. Diba sa Hollywood, gusto magpa-insure ng legs, ng mukha, ng breast, kahit magkano, basta kaya nyo magbayad. Okay. Now, I'll make this chain story para maalala nyo. Okay. Magbigay ng pangalan. Okay. Para masaya. Anong pangalan mo, iho? Ha?
JR.
JR. Okay. Ikaw ay si? Kat. O, si JR. Si JR ay boy sa mga hindi nakakita. Si Kat ay girl. Okay. Si JR at si Kat. Now, si JR at Kat ay mag-office mates. Okay. Now, nagkainlaban sila. Si JR kumuha ng insurance sa buhay niya, designating Kat as beneficiary. They are single. Is that valid? Of course, the answer is yes. Because if you take an insurance upon your life, no question you can put anyone as beneficiary. Okay? Pero kung paano ganito? Si JR at Kat ay magjowa. JR took an insurance on Kat's life and designated himself as beneficiary. Pwede ba yun? Hindi. Kasi hindi sila magkarelasyon under Section 10. They are just jowa, right? Paano gawin natin ito? JR and Kat are magjowa. They got married. Huwag kang masuka. They took an insurance. So then, kasama na sila. JR took an insurance on the life of Kat, designating himself as beneficiary. Is that okay? Yes. Because they're already husband and wife. Okay. Paano kung JR and Kat are just magjowa? And then JR took an insurance on the life of Kat. Magjowa lang sila and designate himself as beneficiary. Pero they got married naman later on. Okay. Is that okay? The answer is no. Bakit? Marriage will not have retroactive effect. Because the law looks only at the time the insurance takes effect para pagkabahan may piring. Dito na kayo titingin. Meron na ba kayo insurable interest at this point? O yes or no lang, wala na. Okay. Now, let's go back to the story. JR and Kat. JR and Kat are husband and wife. Now, JR and Kat will facilitated the recording of a lecture. At dumating doon si JR, Kat, and Darling. Leonard. JR, Kat, and Leonard. Now, nagkatitigan si JR and Leonard. So, ano nangyari? Iniwan ni JR si Kat. So, it's already now JR and Leonard. And JR and Leonard were happy. So, JR then decided to take an insurance on his life and designated Leonard as beneficiary. And they were there for the next 30 years. So, ang insurance to kailan mamatay? JR, the debts. Now, sa libing, sa burong pala, nakatayo si Leonard dun sa kabao ni JR. Biglang dumating si Kat. Sabi ni Leonard, ano ginagawa mo dito? Ayoko na skandalo. Sabi ng Kat, wala akong pakialam dito. Ang habol ko lang ay pera dahil nalaman ko na ang beneficiary na insurance ni JR ay ikaw, Leonard. So, ngayon, tanong, sino ang wagi? Team Kabit or Team Legit? O diba? Anong winner? Team Kabit. Bakit? Sabi niyo sa akin, ay Judge, di ba may maramag versus maramag? Tama. Ano ba ang definition ng adultery or concubinage? Adultery is married woman and a man. Ano concubinage? Man versus woman. Ano ba to? M to M. Pinagbabawal ba ng batas? Wala sa batas. So unless we see jurisprudence changing the maramag doctrine, expanding to same-sex, then this will be the answer. Okay? So this is, again, let's further, subject to further debate. Let's see what will be the jurisprudence of this. Pero we are copying the precise definition under the revised penal code. Bakit? And let me illustrate. There was one bar exam in the past. I think it was 2015. Anong kwento? Alam ko mahilig kayong kwento kasi matutulog kayo pag walang kwento. Okay? Itong kwento. Ikaw ay nagsiswimming sa Boracay. Tapos may umaho na sexy na ka-two-piece. And then sabi mo, uy, ligawan ko nga. Niligawan mo si sexy. At sinagot ka. And you got married, beach wedding. Now, you took an insurance on the life of your sexy wife and designated yourself as beneficiary. Now, 2 years passed, 3 years, but hindi nabubuntis. So, hinayaan mo lang na your wife died suddenly. So, you had her autopsy. And now, you found the reason why hindi nabuntis. Yung pala, siya yung classmate mo nung elementary, si Baldo, na nag-change sex surgery sa Thailand. Therefore, remember, you were married, then you took an insurance. Paano yung insurance nyo? Hindi pala valid yung marriage nyo. Right? Because lalaki siya hindi mo lang na-discover. Well, what then will happen? There could be recovery. Why there could be recovery? Unless there is a judicial declaration. Okay? Unless there's a judicial declaration. So if there's no judicial declaration yet, then there can be recovery. But if there was a judicial declared that your marriage is void, then that is the time that you cannot recover. Okay? Take note, kahit alam naman natin lahat, that is a void marriage. You still need to file a case in court, diba? Diba, void marriage, ganon. You have to still file an action in court because only the court can say that something is void. It's always the presumption of validity. Hintayin nyo lang muna maging huwes kayo katulad ko bago sabihin yung something is void. Okay? Now, let's go to, Now, let's go down to the other side. Insurable interest in property. In property, it consists of any of the following. Existing interest, inchoate interest, and expectancy, but for inchoate and expectancy, both must be coupled or anchored in existing interest. Okay? Existing interest, simply ownership of a thing. Like, paano kung ganito, bumili kayo sa Shopee, practical. Di ba merong insurance? Pwede ba yun? Hindi mo pa nare-receive yung item? The answer is yes. Because it will fall under the category of inchoate expectancy, coupled with existing interest. Okay? This is something which is yet to arrive. Kailangan ba dapat na meron kang ownership of a thing to constitute interest? Well, if you're just, say, a lessee, pwede ba? In the case of owning sin, a lessee has insurable interest over the leased premises. Paano if you have a friend and you're using the car of your friend? Your friend has no insurance on his car. Can you take an insurance for your friend? The answer is no. Because again, you are not a lessee. You are just borrowing it. So you cannot take an insurance over that car. Okay? Now, ano naman yung inchoate interest? Founded existing interest. Inchoate means something which is not yet full. Okay? But it will become completely your own. Partial. Example, may bahay ka. Kumuha ka ng insurance sa bahay mo. Yung bahay mo na foreclosed ng mortgagee. Now, the mortgage, there's a highest bidder, si X. Pwede bang kumuha ng insurance si X doon sa bahay? Ito example ng inchoate interest, found existing interest. Bakit? You are the owner. You can still insure that property because you have a redemption period. In the same way, the highest bidder can also insure the property because he also has an inchoate interest. There's a probability that you will not redeem the property within 1 year. Therefore, the interest will be full after the expiration of the 1-year period. Pero in the meantime, both parties can get interest as insurance over that house. Okay? So, expectancy. Paano kung expectancy? Say, your father made a last will and testament saying that you are the tagapagman of this house. So, excited ka, kumuha ka ng insurance dun sa mansyon ng tatay mo. Namatay ang tatay mo sa sunog, pati yung bahay na sunog. Oh, can you recover? Can you recover from the life insurance can you recover from the insurance on the house? The answer is no. Why? Because you are the one who took an insurance on the house and you have no insurable interest yet at the time. Because the owner of the house is your father. Remember, even if you have a will, the will will only operate upon the death of the person. So, your father was still alive. That's why you cannot get an insurance at that point in time. Okay? Now, in property insurance, you must have insurable interest in the subject matter of insurance. So, example again, meron kang kaibigang milyonarya, kumuha siya ng life insurance sa buhay niya, kumuha rin siya ng insurance sa bahay niya, ikaw ang beneficiary. Nasunog yung bahay, na-debts din siya. Can you recover? Yes, only for the life, but not for the property because you're just a friend. Okay? At what point in time balikan natin in property, must insurable interest exist? In property, dalawang periods. In take effect and the time of loss. But need that exist in the middle. Therefore, kung may bahay ka, kumuha ka ng insurance, binenta mo yung bahay mo, tapos later on, nabili mo uli ang bahay mo, within the duration of the policy, if your house was destroyed, you still can recover because even if you had lost possession of the house in the middle is immaterial in the story. You look only at the time the insurance take effect and the time of loss, not in the middle. Okay. How much in property insurance is limited up to the value of your interest because we follow the principle of strict indemnity. What does it mean? You are not allowed to profit for your loss in property insurance. Okay. You will see the slide, there's also a new case, the case of UCPB versus Asgard. In this case, it says that even if you are not the owner of the property, you can still have insurable interest. Why? If you will be benefited by the continued existence of the property or will suffer a direct pecuniary interest, a pecuniary loss by its destruction, even if you have no legal title. Because here, ang kwento nito ay may equipment at machinery. Yung machinery, ibang owners sa owner equipment. Pero the parties had agreed pursuant to contract to make corrugated boxes using the machinery equipment combined. Eh kaso, tinanggal mo yung equipment sa machinery. Yung machinery nasira in the process. So, then is that destruction made by you also would it also affect the owner of the machinery? This actuation on your part involves the two of you, even if there are two owners, because you bound yourself pursuant to contract to make corrugated boxes. Yun yung basis, kaya even if the destruction was made by another person, that other person is not considered a strange to contract. It is as if he is also the owner of the property. That's why there's no recovery from the insurance. Okay. Now, so far as representation is concerned, is there a difference between intentional and unintentional concealment, meaning hindi mo sinabi? There's no difference. Rescission is a remedy. Good faith is not a defense. Eh, paano kung misrepresentation? This time, rescission is available only for intentional misrepresentation. In the case of Insular Life, sinabi niya, insured, na siya ay 55 lang. Pero actually, overage na siya. Is this misrepresentation or is this concealment? This is actually misrepresentation. Because in concealment, you did not say something. This is misrepresentation because you said something, but this something is wrong. Pero tanong, sinadya mo ba ito o hindi? The Supreme Court said this is unintentional. So there's no remedy for rescission. Bakit unintentional misrepresentation? Well, there's only one document which was submitted evidence showing that there was a wrong age. And the Supreme Court said could have been an isolated mistake because you, in insurance, you fill up a lot of documents showing your age. Show us the age, the other documents, pero hindi pinakita na insurance company. So there's a presumption then that evidence suppressed would be adverse when presented. Okay? Now, in case of misrepresentation, I've said earlier, the remedy is a rescission, but it must be exercised before the commencement of an action and a contract. Meaning, before a case is lodged. So, pag naunahan ng demanda, hindi na pwede ang rescission. Okay? Ang tinatanong dito is all about IC, Incontestability Clause. What are the requirements of IC? First, it must be a life insurance, payable on the death of the insured, 2 years from issue date or last reinstatement. The policy could not be proven void or rescindable by the insurer. The grounds are limited only to concealment or misrepresentation, not to any other ground. Now, ang problema dito kasi sa incontestability clause ay dumating ang Sun Life versus Sibia case. Kasi nung una, simple lang IC. Magbilang ka ng 2 years. Lampas ng 2 years, okay, policy is incontestable. Ganun lang. But when Sun Life came in, it says that even if the policy is less than 2 years, but the insured died within the time frame before 2 years had lapsed, the policy is already incontestable. So how will you then reconcile the answer of Sun Life versus Sibia versus the other Supreme Court cases on concealment? I always suggest you answer the traditional answer, but add as an additional sentence. However, in the case of Sun Life versus Sibia, if the insured dies before the lapse of the incontestable period, the 2-year period, but policy is already incontestable. That having sealed the lips of the insured. So I add that only as a secondary answer, not a primary answer. Take note, hindi pa tinatanong ang Sun Life versus CPI. Now, let's go to premium. Premium is the amount paid by the insured insurance company. What if you paid only half? Partial payment of a premium makes the entire contract effective. What if you pay only through an agent? Payment to an agent is a valid premium payment in favor of the principal, following principal-agency relationship. Okay? Now, in case of loss, you are required to submit notice of loss, right? However, what if, despite submission of notice of loss, the insurance company failed to notice that there was failure on your part to submit the original documents, like in the case of IPAMS versus country bankers. Even if you did not submit the original receipts, but insurance company acknowledged the indebtedness and promised to pay within a certain time frame, then that is considered waiver of the defects in the notice or proof of loss. Okay? Now let's go to double insurance. Double insurance and overinsurance are asked alongside. Double insurance requires 5 elements. Okay? Same person, 2 or more insurance companies, same subject matter, same interest, same peril. Overinsurance is simply taking insurance beyond your insurable interest. So overinsurance is simple math. But in double insurance, you look at elements. Okay? Now, let's, example ng double tsaka over para maintindihan nyo. May bahay ka, 5 million. Kumuha ka ng fire insurance, 5 million. Company A. Fire insurance company B, 10 million. 5 plus 10, 15. Over insurance. Pero is there double insurance? Company A and company B. The answer is yes, because it is the same peril, fire, same insurance company. Pero paano kung halimbawa, flood insurance company A, fire insurance company B, 10 million, hindi na pwede ang double insurance. Kasi, hindi yan double insurance because the perils are different, fire and flood. Paano kung nag-insure ay mortgagor, tapos nasa isa naman mortgagee, ay hindi rin pwede kasi 2 different interests. Okay? So, what is the rule when there is over and double at the same time? The insured can claim payment in any order which selects, up to the amount the insurance companies are severally liable under contract, and the insurance company is liable ratably to the loss. So, we will apply ratio and proportion. Math na naman. That is called the principle of contribution. So, let's go to the slide. You see here, 5 and 10 million. The house is 5 million. So, what if the house was completely destroyed? You are the owner. From whom can you go? You have the option to go after A or B. If you choose to go after A, pwede ba sabihin ni A na huwag akong magbayad, ayoko doon kay B? No. Because the choice is yours. Now, paano kung you choose B? And then B, insurance is 10 million. Can you get 10 million? No. Because under the principle of strict indemnity, you can only receive up to 5 million. Paano ngayon? Kung nagbayad si B, what then will happen? B can ask for contribution from A. Kaya tinawag na principle of contribution. Applying math, 5 over 15. So 1/3, 2/3 would be the sharing agreement. Okay? May tagal ko na binabantayan to collateral source rule insurance because there is one landmark case, the case of Mitsubishi Motors. What does collateral source rule mean? The defendant is prevented from benefiting from the receipt of money by the victim from other sources. Okay? In the case of Mitsubishi Motors, there is a collective bargaining agreement for hospitalization benefits. Pero the employees have their own MaxiCare, Medicare, etc. Kung ikaw empleyado, pwede ka bang kumuha twice? Isa sa MaxiCare or Medicare, isa sa CBA? Sabi ng Supreme Court, hindi. Isa lang. Why? Because you cannot apply collateral source rule because this is a no-fault insurance. Meaning, there's no determination of who is at fault. So, your recovery can only be against one Otherwise, it will result to unjust enrichment if you are paid twice for the same thing. Okay? That's collateral source rule. Now, let's go to transpo. Lahati na tayo. Sa transpo, ang paboritong tanong ay all about private and common carrier. Okay? So, distinguish private from common. In private, you see in the slide, without making the activity a vocation, without holding self or itself out to the public, etc., to transport goods or person from one place by special agreement in a particular instance only. But for common, you offer your services to transport to the public. Now, the law that you will use in private is ordinary contracts of the Civil Code. In common, you will use common carriers under the Civil Code, Public Service Act, and later on in our special laws. The degree of diligence for private is only diligence of a good father of a family, ordinary diligence. But for common carrier, it is extraordinary diligence, meaning of the highest. There's always the presumption that if a person dies or is injured, it is automatically the fault of the common carrier. Okay? We don't make distinction between a principal business or a sideline, or you offer it on a regular or scheduled basis, or on an occasional basis, or to the general public, or at the narrow segment of society. When you say public, there is one case, the case of LTFRB versus Venezuela. It's all about the transport network companies and transport network vehicle services. So when you say transport network companies, these are the organizations which provide pre-arranged transport services. Sa simikling Tagalog o Grab ba? Yan. Or ano ba? Yung mga share ride service, Grab, Uber, walang Uber nga ba sa Pilipinas. Ang CAS, yan TNC. TNVS is the public vehicle accredited with the TNC. Okay, which is granted franchise by the LTFRB to run the public transport service. In the case of Valenzuela, nasabi ng mga angkas bikers, ay private carrier kami. Kasi hindi mo naman kami ma-hail, mapapara sa kalye, di ba? You can only hail us if you have an app of angkas online. So we are private carrier. Tama ba yun? No. So Supreme Court said, when you log in, you make your service available to everyone who is online. So the law does not make a distinction whether you have a cell phone or no cell phone, or whether you have the own angkas app or no app. Pareho ka pa rin. Part ka pa rin ng public. Whether you belong to the general or to the narrow segment society, you're still part of the public. Okay? Now, in common carrier, whose burden is it to prove that there is negligence? Okay? When a passenger is injured, there's the automatic presumption that that is the fault of the carrier. So, let's take an example. Again, sumakay ka ng bus. Nabunggo ang bus. So, nag-file ka ng case for breach of carriage. Ang sinabit mo evidence ay, yun nga, affidavit mo, plus yung affidavit ng doktor na nag-treat sa'yo. Now, the bus company, when you rest the case, filed a demur to evidence, say, hoy, pasahero, hindi ka nag-present ng evidence showing na ang driver namin ay hindi nagsiseminar, ang bus namin ay walang regular PMS, etc. Is it the burden of the passenger? No. When the passenger is injured, there's automatic presumption that that is the fault of the common carrier. In short, the burden is shifted to the common carrier to prove that it observed the extraordinary diligence. And that was just a result of a fortuitous event. Okay. Now, there's one case regarding illustrating negligence. The case of WGNA shipping lines. There is a 16-year-old minor who rode a boat to Zamboanga. Hininakatin ng Zamboanga. Later on, hinahanap siya sa loob ng barko. Ayaw papasukin ng magulang. Pero nakita a few days later, yung katawan niya ay palutang-lutang sa ilog. Ngayon, when was there negligence there on the part of the carrier? The Supreme Court said yes. Why? What are the badges of negligence here? First, there's nothing to show on their policy what will be their policy if there will be a minor who is unaccompanied and will be riding a boat. And number two, there is no, they failed to accede to the request to look inside the ship when the police as well as the relatives asked for help to look inside. And number 3, the body of the victim was raped, bore bullet wounds, and the bullets matched with the bullets assigned to the security of the shipping line. So there were liability in the part of the shipping lines. Okay. Now, sa transpo, may isa akong binabantayan all about the Montreal Convention kasi hindi pa nagtatanong. Pero di ba, nabago na ang Warsaw, Montreal Convention na tayo. Ang binabantayan ko dito is regards action for damages because we have a new jurisprudence. We have a new law regarding this. Now, in an action for damages, you can file a case at the option of the plaintiff, either at the territory of one of the state parties, before the domicile of the carrier, or the place of business, or where the contract was made, or the place of destination. In the case of Luwilier, si Luwilier ay taga Makati. Sumakay siya ng aeroplano, British Airways, from London going to Rome. But he was humiliated by the flight stewardess. He was asked to demonstrate safety measures, etc. He felt humiliated. Now, he filed an action for damages here in Makati. But British Airways filed a motion to dismiss because sabi niya, walang jurisdiction ang Makati. Tama ba yun? Under Montreal Convention, in an action for damages, the plaintiff can file where? First, territory of the state parties, either court of domicile of the carrier. Ano ang court of domicile ng British Airways? Eh, di ba UK? Principal place of business of British Airways? UK. Where was the contract made? Binili ticket sa London, UK. Destination, London. So, London to Rome. Rome is Italy. Therefore, your option is just UK or Italy in an action for damages. Pero hindi nga doon file. Therefore, the case was dismissed. Hindi pwedeng gamitin ang residence of the plaintiff kasi taga Makati si Luwilier. Okay. However, ito sinasabi ko may bago. At yung bago, you see the slide, nakasulat na nga bago ha, may words na capital bago. If, however, it is a case for damages due to death or injury of passenger, may dilagdag. Maliban mo sa 4 na sinabi ko, or territory of a state party in which, at the time of the accident, the passenger has his principal and permanent residence. Nationality is not the factor. Okay, let's take illustration. Ikaw ay nag-asawa ng AFAM. Yung AFAM ay American citizen. Anong AFAM? Don't tell me, hindi nyo alam. AFAM, sagot sa kahirapan. A foreigner assigned in Manila. Okay. Your spouse became a resident of Manila. So, establish kayo na family home ng AFAM nyo dito. Now, yung British employer ng AFAM mo, nagpadala ng Japan Airlines ticket bound for London. So, flight is London to Tokyo, Japan Airlines. However, yung AFAM mong asawa ay namatay sa plane crash nearing Tokyo. So, saan mo ipapile ang case? US, UK, Japan, Philippines. Basahin natin, ang sabi ko kanina, may dinagdag. Kung hindi dinagdag yung territory of a state party where at the time of accident, passenger has residence, hindi ka makapag-file ng Philippines. Abroad. Kasi hindi kasama yun. Pero because of this amendment by Montreal, pwede na. Why was Montreal amended? Because there's always a clamor in the past. The victims cannot recover because they don't have money. Airfare pa lang, papunta ko sa ang bansa. Hindi ka nga mabigyan ng visa, papunta doon. O, file ka ng case doon. So, that was the problem. And it was addressed pursuant to the Montreal Convention, where you now look at residence, no longer at national. Okay? So, that's it with transport. We go now to the new Central Bank Act. Sa new Central Bank Act, ang paboritong tanong is all about close now, hear later doctrine. Ano yung close now, hear later doctrine na yan? When there is a report from the supervising or examining department that a bank or quasi-bank has any of these enumerations under the slide, A, B, C, D, or dormant for 60 days, unable to pay liabilities to become due, insufficient realizable assets, cannot continue business involving probable losses, violated since this is order, what will happen? Kaya close na here later doctrine, the monetary board will, without need of prior hearing, will forbid the bank from doing business. It will designate the PDIC as receiver, and for quasi-bank and non-stock savings loan association and a person recognized competence, the PDIC will go with the liquidation. Hindi ba ito violative of due process? Kasi close now, here later. Well, this has a practical reason because if you will allow them to dispute the findings, then money will be dissipated. Ubus silang na withdraw. Okay? Now, these actions will be filed executory, cannot be restrained. You cannot get it except via certiorari, that there was grave abuse of discretion. And certiorari can also only be filed by the stockholders representing majority of the capital stock within 10 days from receipt by the board of the order. So, limited lang ang right mo. Pwede bang sabihin ng bangko, teka, bakit naman agad-agad tayong receivership? Hindi pa pwedeng conservatorship muna. Because in conservatorship, the bank will still do business. But in receivership, the bank cannot do business. Pwede bang step 1 muna? Answers no. The Vivas case says that it is exclusively with the monetary board. The decision is exclusively with the monetary board. It is not a condition that there should be conservatorship first before receivership happens. Okay? So, yun lang ang topic na importante doon. Let's go now to the bank secrecy law, which is peso and foreign currency. Kasi kung peso, what we apply is RA 1405. Pag foreign currency, we apply RA 6426. Under bank secrecy law, all deposits are absolutely confidential, including investment in bonds, like treasury bills. These are considered absolutely confidential. Cannot be examined by any person, government official, bureau, or office except, ito na. Examination is made in the course of special general exam or made by independent auditor. Letter C, written permission of the depositor. Insofar as written permission of the depositor, this applies also to foreign currency, not only to peso. Let's take one case, in the case of China Bank versus Court of Appeals. But this again is a pro hac vice ruling, ha? Ano kwento? Tatay at anak, joint account holders sa Citibank. Si anak, sinara ang account sa Citibank, inilipat sa China Bank. Hinahabol ni tatay ang pera sa China Bank, pero sabi ng China Bank, hindi, kasi ang account holder dito ay si anak. Pero sabi ng Supreme Court, this is one of the exceptions. There will be examination in case of written permission from the depositor. And the father is a co-owner because it appears that the funds were taken from Citibank and transferred to China Bank. Pero sabi ng Supreme Court, this is pro hac vice, meaning for this particular instance only. You cannot apply this as a general rule. Okay? What else? In case of impeachment, pero pag impeachment, peso lang ito, ha? Sa mga ko na aking mahiwagang slide, pag may nakalagay na FX also, meaning peso and FX, pero pag walang nakalagay na FX, applicable lang ito sa peso na bank secrecy law, hindi sa foreign currency. Bakit? Kung konti lang ang foreign currency. Because the Foreign Currency Deposit Act was passed during a time that we are needing dollars. Kaya kung konti lang ang enumeration provided for by law. Okay? Tandaan nyo sa impeachment, diba? Dati si Chief Justice Renato Corona. Okay, there was a case there about his impeachment and he would like to examine his dollar deposit. Pero ano nangyari? Hindi na-examine kasi hindi na pwedeng gamitin yung batas na ito because this is applicable only to peso. Okay? Next. Upon order of competent court in case of bribery or dereliction of duty, peso lang to applicable. When the money deposited is the subject matter of litigation. Take an example. Ikaw ay empleyado ng isang kumpanya. Ninenok mo yung 1 million. Yung 500, dineposit mo sa yung BDO peso. Yung 500,000, convert mo into dollars at dineposit mo sa yung BDO dollar account. Question, pwede ba yan? May check? Covered by ng secrecy? Yung peso, yes. Because the money is the subject matter of litigation. Pero dollar, hindi. because hindi kasama yung dollar American rules. Okay? Now, inquiry must be, should be, it says, money deposit account itself is the subject matter. Okay? Now, we have a new case, a real bank versus Malinas. Ang kwento ay simple. Cheque. Si Maningas, may account sa Metrobank. Nagpadala siya ng cheque, pambayad kay Rosaria. Hindi natanggap ni Rosaria kasi may naka-intercept ng cheque at yung nag-open ng account sa thrift bank at pinasok yung cheque sa thrift bank at naka-withdraw doon sa thrift bank. Tanong. Now, the RTC directed Real Bank to produce the records of the impostor. Pwede ba yun? Will it violate the bank secrecy law? Yes, there's a violation. Bakit? Because the subject matter should be the actual money itself, not the mere money equivalent of the check. Magkaiba yung cheque sa money itself. Di ba? Medyo technical, wala tayong makagawa. So, you cannot apply if the examination there is about the records of the account holder. But the subject matter should be the money, not the money equivalent of the checks. Okay? Now, in the case naman of Salvacion versus China Bank, which is another proactive ruling, isang Amerikano ng rape ng isang 12-year-old, nanalo yung bata, pero ang pera pala ni Kano ay puro dollars sa China Bank. So, ano kung sa garnishment must serve? Pwede bang i-garnish? Unfortunately, under Republic Act 6426, foreign currency deposits are exempted from attachment or garnishment by any court. Now, how about this case? Sabi ng Supreme Court, it allowed garnishment because it will result to an empty victory on the part of the victim. But again, the Supreme Court said, this is only a pro hac vice ruling na awa lang. So, hindi mo pa rin ito pwedeng magamit as a general rule. Okay? Now, the BAR, on the other hand, can the BAR examine bank deposits? Whether foreign currency in peso? Yes. In relation to certain matters. Example, paano kung halimbawa, si BAR napansin niya na, bakit parang nagsasubmit ang BAR lagi ng mga summary ng mga top 10 celebrity taxpayers. Bakit itong si celebrity, halimbawa, si Vice Ganda, ang dami niyang endorsement, but parang hindi siya top 1. So sabi ng BR, I will examine BDO to check how much is his money. Can that be done by BIR to ascertain the correctness of his taxes? The answer is no. Because BIR can only check in 3 instances. Anong 3 instances? Gross estate of a decedent, meaning namatay, or taxpayer who applied for tax compromise because of financial incapacity. What else? A specific taxpayer subject of a request for the supply of tax information for a foreign tax authority pursuant to a convention or agreement on tax matters. Hindi rin ito. What the EBR would like to do is a fishing expedition, which unfortunately is not allowed by law. Okay? Sino pa ang pwede ma-examine? Kasi di ba sabi any o BIR pwede in those instances. How about the Anti-Money Laundering Council? Can it examine? Yes, in certain instances. There are 2, without court order and with court order. So the Anti-Money Laundering Council can examine peso or foreign currency without court order in case of KDHAM. Isa na namang acronym ko. Ano yan? Kidnapping, drugs, hijacking, arson, murder, terrorism. Pag yan ang predicate crime, pwedeng mag-examine, walang court order. Pero kapag iba na ang predicate crime, kailangan na ng court order. Okay? So, you see in the slide, ano-ano yung mga crimes in detail ng, naman the definition of kidnapping. Terrorism, there is a enumeration under the Human Securities Act, which is the slide. Now, for drugs, it's from importation down to plant cultivation. Okay. Now, yung sinasabi ko naman kanina na there is a court order required, it is only an ex parte application. If there was probable cause that deposits relates to certain unlawful activities. Ano yan? Anti-Graft and Corrupt Practices Act, specific paragraphs ng Anti-Graft and Corrupt Practices Act. These paragraphs pertaining to receipt of money in exchange for something else to be done by the government employee. Okay. Plunder. Anong plunder? Ill-gotten wealth, magano? 50 million. Robbery and extortion, look at the revised penal code. Wedding and masyaw, piracy, qualified theft, swindling, smuggling, e-commerce violation, marami ito, bribery, fraud, malversation, forgery, anti-trafficking, revised forestry code violation, fisheries code violation, mining act violation, wildlife resources conservation violation, national caves anti-carnapping, illegal possession of firearms, anti-fencing, illegal recruitment, intellectual property code violation, anti-photo video voyeurism, child pornography, 7610, Securities Regulation Code, Strategic Trade Management Act in relation to weapons of mass destruction, violations of tax code, but the council cannot institute for future proceedings if it was already recovered by the DAR in separate proceeding, anti-online sexual abuse law violation, and felonies or other similar matter that are punishable under the penal laws of other countries. Itong enumeration na to, nagtanong sa bar before, give at least 5 predicate crimes. So, pag ganun tanong, talagang magtatalo na kayo sa tuwa. Pero, kasi kung ang bar examiner magpapahirap sa buhay, gagawa yun ng kwento. Halimbawa, okay, let's go back to this enumeration para maalala nyo ay yung kwento. So, it says the Anti-Money Laundering Council can examine upon order of the court upon an ex parte application when established that the deposit relate to the following unlawful activity. The Anti-Money Laundering Council will be examining your account. Kasi, sabi nila, it will apply for to apply with the court for examination because of violation daw of the AMLA, Anti-Money Laundering Act. Ikaw ay, ang deposit mo ay sa BDO. Ang kwento ay, ikaw ay engaged sa, meron kang OnlyFans account. Alam nyo OnlyFans? Kung hindi nyo alam ang OnlyFans, kung may OnlyFans account ka. So, may pumapasok na pera kung saan-saan. So, can the Anti-Money Laundering Council then examine this account of yours with BDO because you have an OnlyFans account? Ano bang ginagawa mo doon sa OnlyFans account mo? O kung ano-ano mang pinaparequest sa'yo? Will it fall under an unlawful activity? Okay, halimbawa, ano ba sikat ng OnlyFans? O sabihin na lang natin na doon sa minamanage mong account ay ikaw ay nagsasayaw ng hubad o kung ano mang i-request sa'yo. Okay. Will it fall under any of these violations, unlawful activity? Okay. Halimbawa, paano mo iyon? Ano? JR. O, si JR. May OnlyFans account siya. O, tapos siya ay naghuhubad doon, nagsasayaw-sayaw. Nalala ko tuloy yung news before na yung nagkaroon ng bahet lupa ang isang gay bar dancer nung pandemic dahil meron siyang online account. Ayan. Will it fall under this? Is this Anti-Graft and Corrupt Practices Act ginagawa niya? Kaya pwedeng examine ng council? Hindi naman, no? Anti-Graft and Corrupt. Hindi naman ito government employee. Is it plunder? Plunder ba ginagawa mo? Hindi. Robbery? Hindi mo naman pinipilit, di ba? Oh. Is it wedding and masyaw? Illegal gambling ba yan? Pirata ka ba? Qualified theft ba to? Estafa, hindi ha? What you see is what you get. O, smuggling ba itong ginagawa mo? E-commerce violation? Hindi ko makita. Bribery? Fraud? Malversation? Forgery? Anti-trafficking? Is this anti-trafficking? Remember, you're the one doing it on yourself, not you on others. Forestry? Ibang gubat yung pinakita mo. Isda? Hindi rin ito. Mga fisheries? Mining? Kuweba? Wala rin. Wildlife resources? Carnapping? Illegal possession of firearms, ibang firearms naman yung pinakita mo. Fencing, migrant workers, intellectual property, anti-photo and video voyeurism, pwede ba ito? Itong anti-photo and video voyeurism applies only to someone else, not you. So if you do it by yourself, it's not anti-photo and video voyeurism. Anti-child pornography, matanda ka na hindi na pwede yan. So, child abuse, hindi rin. Securities Regulation Code, hindi rin. Weapons of mass destruction, ibang weapon na pinakita mo. Tax code, hindi rin. Anti-online sexual abuse of children, hindi ka na bata. In short, hindi siya kasama. Ganyan yan, pwedeng magtanong sa bar. Mag-iisip sila ng crime, tapos, o anumang activity, tapos will you in your made to say, teka, kasama ko to sa enumeration ng crime? Oh, medyo mahirap, no? Wala tayong magagawa. Ganyan yung mga para-paraan para pahirapan ang examinee. Okay? Now, let's go to GBL, General Banking Law. Ang paborito tanong dyan ay the kinds of bank. Okay? What are the kinds of bank? Union. U is universal. C is commercial. Thrift, rural, cooperative, Islamic. Walang blood bank, ha? Wala ring family bank. Iba yun. So, bakit sila may category? Okay? It depends because the category is based on their market segmentation as well as their capacity. Because a universal bank among all kinds is the one which is the biggest. It has the most power. It has the power of a commercial bank. It has the power of an investment house. It has the power to invest in both allied and non-allied, meaning nothing to do with banking. Pwede mag-invest a universal. Bakit? Malaking capital. Pero commercial, hindi pwedeng investment house. Hindi pwedeng non-allied. Dapat allied pa rin. Okay? What else? A universal bank, because it has big funds, it can invest up to 50% of its net worth. Pero ang commercial, mababa hanggang 35 lang. Pero both universal and commercial can invest only up to 25% in just one enterprise. Meaning, do not put all your eggs in one basket. Hindi pwedeng buhos lahat. Okay? Now, thrift bank, rural, cooperative, Islamic, because of their market. Hindi pork BDO sa probinsya, rural bank yun. Hindi. Okay? So, rural bank, covered by Rural Banks Act, Thrift Bank covered by Thrift Banks Act, Cooperative covered by the Cooperative Code, Islamic Bank covered by Islamic law. So, iba kasi Islamic law insofar as regular laws in banking. Now, these are just the other category. Pero paano digital banks? Uso ngayon, di ba? Is digital bank another category of banks? Digital banks only mean that all their functions are performed digitally, paperless. The law does not prohibit naman a regular bank from doing paperless transaction. So if you will make digital bank as a category, then the correct category is not digital. It is non-digital versus digital. Hindi siya pwedeng sumama sa universal, commercial, thrift, hindi. Kasi ang universal, pwede rin naman siyang digital banking. Okay? Now, in the, what would then, di ba sa bangko, tayo yung depositor. So tayo yung customer, tayo yung creditor. The bank is a debtor, right? Now what is then the responsibility of a bank insofar as the depositor is concerned? So it's extraordinary degree, okay? Now, how about if there will be a drawer who will be paying a check, okay? What is the liability then of the bank insofar as the checks which were issued? In case of an authorized payment, the drawee bank is liable for the amount of the check. The drawee bank then can claim reimbursement from the collecting bank. Let's make it simple para maintindihan nyo. Ikaw ay may bangko, BDO. Nag-issue ka ng cheque para sa kaibigan mo kay X. Pero yung cheque na napunta kay X, nakuha ni impostor Y. Si Y na deposito sa bangko niya BPI. Therefore, si Y, dahil deposito ang cheque, nabayaran si Y. Paano yung check, yung galing kay depositor na sabi niya ay para ito kay X, hindi kay Y. Paano na yun? Well, even though there was payment, the one who will be held liable is BPI, the collecting bank, not the drawee bank. Bakit? The obligation of the drawee bank is to pay only the person authorized by the drawer, meaning X. So if there was payment to Y, if the account of the drawer was deducted, the drawee bank can go after the collecting bank. And the collective bank should then pay the drawing bank, and the drawing bank should refund the customer, the drawer. Hindi ba unfair kay collecting bank? Kasi di ba sa collecting bank, malay ko ba na peke yun, na intercept lang yun, hindi ko alam. Hindi. Because what we follow there is a rule in negotiable instruments law na hindi nakasama sa bar examination, unfortunately, where a collecting bank acts as an endorser. An endorser has warranties and warrants that the instrument is genuine in all respect what it purports to be. Kaya hindi pwedeng sabihin, ay nanakaw na intercept. So, kawawa ang collective bank lagi sa ending being an endorser. But that rule has an exception. Ano exception? If there is negligence on the part of the person. So, how is negligence shown? Well, it's your omission to do what you are supposed to have done. In one case, the case of Elosorio, yung kanyang secretariat, authorized niya before na mag-conduct ng banking transactions niya. Ngayon, yung pala, yung secretariat niya, personal niyang yung pera sa account ng kanyang boss, kinukuha niya dahil nag-forge siya ng mga cheque. Pero, nalaman lang yan ng boss after 2 years. Bakit? Kasi, hindi siya nagre-reconcile ng bank statements. Pag dumarating yung kanyang bank statements, check kung ano ba yung puwas, kung ano ba, hindi, walang pakialam. Nalaman lang niya, nung may kaibigan siya nagsabi na, oh, baka na secretary mo nasa bank ko, ganyan. So, he was alerted. Now, what the Supreme Court said, applied there is estopel, negligence. Because even if his signature was forged, the proximate cause is not the forgery. It is the failure to examine the bank reconciliation statements. Okay? Take note, this is part of the new bank syllabus. Hindi ito dati sinama na ngayon ito. Pero unfortunately, mayroong parang negotiable instrument aspect. Now, and so far as granting of loans, okay, there is a restriction on bank exposure to those three. Those three means director, officer, stockholder-related interest. They cannot borrow. They cannot, as a rule, become guarantor, endorser, or surety from their bank in which they are connected, except if there is written approval of majority of all directors, excluding the those three concerned. So in short, pwede pa rin namang magutang, but there is a qualification on who should approve. And moreover, if there is a fringe benefit plan approved by the BSP, that will be the limit. Okay. Now, let's go now to Anti-Money Laundering Act. So, sa AMLA, hindi pa rin nagbabago ang cover transaction. Magkano? 500,000. In excess of 500,000 within 1 banking day. In short, pag chinap-chap mo, ganun pa rin. It will all be summed up, 500,000 within 1 banking day. For casino naman, single cash transaction in excess of 5 million. Pag real estate broker, single cash transaction, 7.5 million. Take note of the amounts kasi madaya tamosing ang casino. Dapat single casino cash transaction, 5 million. E di pag chinap-chap, excuse. The same way with real estate brokers. Pag chinap-chap, di hindi na. Pero kapag bank, pwede chap-chap. Diba? Well, that's a provision of law. So these covered institutions are obliged to report to the council these transactions, covered transactions, suspicious transactions. But what if, say, you are a lawyer, and then your client approach you and ask for legal advice, present to you certain documents, and you, upon scrutiny of the documents, were able to decipher that your clients engage in money laundering? Are you required by law to tell it to the council? Are you required to report? Lawyers and accountants who act as independent legal professionals are not required to report if it was obtained in circumstances where they are subject to professional secrecy. But if there's a difference, if you, however, would counsel on how to avoid, abet, money laundering, that's different. That's already penalized. Pag-iba yung counseling versus discovery of the information. Okay? Paano kung nireport mo, the bank reported, pero nagkamali ang bangko? Can you now go back against the bank, file an action for damages for besmirched reputation? Kasi napaghinalaan ka tuloy na money launderer? The answer is no. But why? Safe harbor provision. No action will lie against person who reported it in good faith. Now, Di ba half million lang? Paano kung less than half million? Pwede ka pa bang ma-report? That's what we call suspicious transactions. Suspicious transactions are transactions with covered institutions, regardless of the amount, where any of the following circumstances exist. There's no underlying legal or trade obligation, not properly identified client, amount not commensurate with the financial capacity, or it is structured to avoid reporting requirements, or related to unlawful activity, or you deviated from the profile. Example, nung mag-open ka ng bank account, sa video, sabi mo, ang laman lang naman ito ay allowances mo galing probinsya. Kasi ikaw ay isang estudyante, wala kang trabaho. Kaso, yung account mo, bakit every hour may pumapasok? Maliliit na amount lang, several thousand, halos every hour. All over the world, the Philippines and the world, and mga sources. Pero lahat sila, pag tinutan mo, hindi naman lalampas ng half million. Pero pasok, labas, pasok, withdraw. Matatag ka pa ba? Because it's less than half million? Answer is yes. Why? Because you see, there is no not commensurate with your financial capacity. Sinabi mo, a student ka lang, wala kang inaasahan kundi allowance. Okay? Or it's obviously deviated from your profile because you're just a law student. You said you have no money, then how come money is coming in, coming out? So yun yung matatag ka pa rin being a suspicious transaction. Okay? So, when is money laundering committed? Money laundering is a crime of omission as well as a crime of commission. Bakit a crime of omission? If you fail to report and you're required to report it, you will also be considered violating money laundering. Ba, sabi ko kanina, the institutions are required to report, fail to report is money laundering. It's also a crime of commission. Paano? When you transact the monetary instrument or property. Take note, hindi cash. It's not just cash. It includes monetary instrument or property. Say, if you convert your cash into jewelry, gold bars, expensive painting, yung pa rin yan. Okay? It's still a monetary instrument or property. You transact, convert, you conceal. Kung nanood kayo ng pelikulang ni Ben Affleck, maganda yon. The Accountant. Yan. Siya yung accountant na money launderer. Kinonvert niya yung pera ng kanyang mga kliyente into gold bullions, expensive jewelry, paintings, etc. Okay? You aid, abet, assist, or counsel the commission of money laundering. So dito mapapasok ang lawyer because you are counseling. Iba naman yung kanina kwento ko that you really discovered. Okay? Let's take recent cases of money laundering. In the case of Yambao versus Republic, there was a freeze order on the funds of Yambao. However, after the lapse of the 20-day period, ang sabi ng CA, we will extend the freeze order. Kasi freeze order, di ba, 20 days lang. Pero sabi ng CA, extended until all proceedings are terminated. Pwede bang gawin nyo ng CA? That is no. Why? Because it will violate the right of the party to be presumed innocent. So, even if it is not yet completed, there's still naman a remedy on the part of the government. Okay, they can file the appropriate case with the regional trial court. It's not required that they extend the effectivity of the freeze order with the Court of Appeals. We have an APO, RTC, Asset Preservation Order, which is has the same effect as a freeze order with the Court of Appeals. Pero pwede ba mag-issue ang council ng freeze order? In only one instance. Only for purposes of implementing targeted financial sanctions in relation to proliferation of weapons of mass destruction and financing. So it's only, again, 20 days, but the party may, within 20 days from issuance, file with the CA a petition to determine the base of freeze order. Paano kung na-frozen na yung account mo? Ibig sabihin ba, hindi ka na pwedeng mag-withdraw? O katulad nung yung kilalang mayor na i-check pala siya, ang dami niya accounts recently which were frozen. Kailangan niya ng legal counsel. Paano yun? Hindi na siya pwedeng mag-withdraw. Paano pangkain niya? Paano yung paggasolina ng helicopter niya? Paano na lahat? Well, the law allows a reasonable amount for family needs and sustenance, including medical services, including legal services. So, hindi mo hindi ka na talagang mag-withdraw. Okay? So, there will be a amount which can be allowed to be withdrawn. And the court cannot issue a TRO. It's only the CA or the Supreme Court who can do so. Okay, now let's go to APO, Asset Preservation Order. Pareho lang yan ng freeze order. It only differs as to the one who issued. Because APO is issued by the RTC, freeze order is issued by the Court of Appeals. Ano naman back inquiry order? In back inquiry order, there's just an examination of the deposits if it's related to a crime. Like in the case of the law firm of Binay, the council filed an ex parte application for the back inquiry over the bank accounts of Subino law firm. That is the Binay law firm. Is there violation then of the right to due process? The answer is no. There's no physical seizure. That is just an examination. And there are safeguards in place during examination. Pwede bang sabay na? Naka-inquiry ka na, naka-freeze order ka pa. Pwede naman. There's no law prohibiting the conduct of both because you're applying for an inquiry to acquire information. Okay? And later on, the freeze order, you would like to prevent the movement of the funds. So there's no prohibition on doing both at the same time. Okay, now let's go to IP. Actually, among the subject matters I lecture, intellectual property is my favorite. Bakit? Well, I've gone to training in Japan and in Switzerland last year because of intellectual property. Okay, now let's just differentiate patent, trademark, and copyright. Anong difference in tatlo? Patent refers to invention. Trademark refers to goods or services. Copyright refers to literary, artistic, scholarly, and scientific works. Patent, trademark are registered with the IPO. Copyright is registered with the National Library and Supreme Court Library. Pero hindi yun nare-register, you submit only a copy for record keeping. Ibig sabihin, kahit hindi ka nagrehistro, you are given the right from the moment of creation. Okay? Now, the duration of right patent is 20 years from filing. Trademark is 10 years from registration. Copyright, we have to differentiate between moral and economic right. Because the economic right and the moral right to be recognized as the moral right of integrity of authorship is limited. Lifetime plus 50 years from death. But the right of attribution to be recognized as the author is forever in perpetuity after death. Okay, so do you have example to sa bar? Do you have any article of commerce which has all three? The answer is yes. All of us are staring on our phones or laptop. The patent is on the hardware of our phone or laptop. The trademark is zero, like mine. Apple is a trademark. Copyright is I'm using a PowerPoint. That is software. That is copyright. O diba? All of these are present. Now let's go to patent. The requirement for a patent is that it must be new, involves inventive step, and industrial applicable. When we say new, it is not found anywhere in the world for the last 12 months. That's what we call prior art. Okay? So, if the item was sold first, then a patent was procured, hindi na pwede. Kasi available na siya sa world. That was the case of Kresser precision. Now, the second requirement is it must involve an inventive step. Meaning it is not obvious to a person skilled in art, a person of ordinary skill in that field of invention. And the third one is that it must be industrially applicable. It can be produced and used in any industry. Okay. Now, pag tinatanong sa bar ang patent, normally, ang tanong ay, what are the patentable versus non-patentable invention? Okay. We'll start with discovery, scientific theories, and mathematical methods. For drugs and medicines, the mere discovery of a new form or property of known substance which does not result in enhancement of known efficacy, mere discovery of new property or mere new process, these are not patentable unless you employ one new reactant. Kung buhay pa daw si Albert Einstein, pwede pa bang ipatent ang theory of relativity? E equals MC squared? The answer is no. Because that is a scientific theory. Okay? Paano kung sabi ko discovery? Ikaw ay nakatingin sa buwan, may nakita ka bituin, pero hindi yung bituin na nakita mo, hindi pa nararehistro. Pwede mo ba ipatent yung bituin hindi gaano malingning? The answer is no, because that is a discovery. Now, insofar as drugs are concerned, uminom ka ng glutathione dahil ikaw ay may sakit sa atay. Pero napansin mo na, uminom ka ng glutathione, wow, pumuputi. Pwede ka bang kumuha ng patent for glutathione as whitening ingredient? The answer is no. Because that's just a mere discovery of a new use of an old substance. Pero paano kung, halimbawa, uminom ka ng Viagra? Ang Viagra, pinulbus mo. Nilagyan mo tubig, minix-mix mo siya, pinalamig mo. Tapos nilagay mo sa buhok mong kulot. Aba, no need to rebond. Straight ng hair. Can you apply for Viagra as a hair straightening ingredient? Perhaps yes, because you made changes. You added water. You made it cold, so you employed a rental. Okay? Now, schemes, rules, and method of performing mental acts, playing games, doing business, computer programs. Well, mental acts ay nasa utak lang naman, kaya hindi ka pwede i-patent. Kaya ilabas mo. Computer program kasi is a software, and software is copyrightable. Remember, these three operate on different regimes. Method of treatment of the human or animal body. O ito, natanong na. May heart attack na isang tao. So, to remove the blockade, hiniwa sa chest. Ikaw unang-una nakaisip ng hiwa sa chest. Pwede bang sabihin mo sa iba na, oy, kayong iba, sa kili-kili kayo humiwa. Pwede ba yun? No. A method of treatment is not. Paano kung nangyari ganito? Sige, pwede na kayo lahat humiwa sa chest. You use a stent where you inserted it and then the stent would balloon, mawawala na yung blockade sa heart. Is that patentable? This time, yes. The product of the theory is patentable. But the theory or the methodology itself is not patentable. Okay. What else? Plant variety or animal breed. Ikaw ay nagsiswimming. Tapos merong sumama sa yung parang starfish, pero naglalakad. Tapos sabi mo, parang hayop na parang halaman. So pinalangan mong pet malu. Pwede mong i-register si pet malu? The answer is no. Because that is a plant variety or animal breed. It's pre-existing. You just not discover it. Okay? What else? Aesthetic. Why is aesthetic not that patentable? Aesthetic nga di beauty. So beauty is lahat ng may beauty, literary, artistic, scholar, scientific, any copyright yun. Remember, 3 different regimes, hindi sila nagsasalo-salo together. Hindi naman mekos-mekos na lang. Diba? Now, anything contrary to public order morality, we call that the moral utility doctrine. Example, cloning. Sabi ng iba, cloning ay would fall under the moral utility doctrine because only God can create another one. Now, who owns the patent? The inventor, the heirs or assigns. If there are 2 or more inventors, then it will belong to them jointly. But we follow the first to file rule. Ano ibig sabihin? If there are 2 or more persons who made invention, the right to patent will belong to the one who filed the invention. Paano kung naunahan siya ng iba? Tapos hindi siya nakapag-file, siya naman talaga inventor. There's always a remedy provided by law for the real inventor. But still, what we follow is the first to file, not the first to invent. Okay? Paano kung you were hired to do it? This time, if it is pursuant to commission, if that activity is your regular job, then it belongs to your employer. But if that is not your regular job and you were able to make an invention, even if you used company time and resources, pareho ng rules sa copyright, it belongs to you. Okay? Now, so rights and limitation patent owner, I'll just leave this here. Pati for your reading matter, kaya nyo to. Doon tayo sa infringement. When you say infringement, it means offering for sale using, making, or importing patented product. Or product obtained directly from a patented process or without authorization of the patentee. To determine infringement, we have the test of literal infringement as well as the doctrine of equivalence. Ano ibig sabihin ng literal infringement? You look at the words of the claim. So the court will juxtapose the claim of the patent and accused product to determine whether or not this infringement. But no one will do that. Kasi huli agad kitang-kita. So what people do is use the doctrine of equivalence. We call that function-way result or triple identity test. Meaning, if they have the same function, performs the same way, achieves the same result, there's already infringement. There's also called insubstantial difference test, where the infringer appropriates the patent but you thus makes insubstantial changes. Or the all elements test, which says that the courts consider the individual elements to define the scope of the patent invention. Rather than looking at the invention as a whole. Okay. In the case of Philips Seafood, this is a Justice Lopez case. O yan ha, ikalawang beses na may Justice Lopez case o konti lang dito. So, Yamauka filed a case for infringement against Philips. Ano yun? Kasi sa Yamauka, may patent for a method of curing the fish. So, ang ginagawa niya, yung tuna in-expose sa filtered smoke, pinapalamig between 0 and 5 degrees to preserve. Sabi naman ni Philips, teka, hindi naman kami nagko-cooling unit. Pinapalamig lang namin by itself. Is there an infringement then? The answer is no. Why? Function, way, result. They have the same function. How to preserve the tuna. They have the same result. Preserve the tuna. But they have different way of preservation. It was not shown that the use of the Philips is also the same as that of Yamauka. Kasi kay Philips, kay Yamauka, mayroong filtered smoke at mayroong pang ipabababa up to 5 degrees. Wala namang ganun kay Philips. Okay? So take note of the FWR test. No evidence presented that this will produce the same effect, the two methodologies. Now, let's go to trademark. Trademark means any sign capable of distinguishing the goods or services. So it can be trademark or service mark. Pareho lang yan ng category. Okay. Sample, yung McDo, yung M ng McDo, that is actually a service mark because McDonald's is engaged in the food industry. The trademark there, the Big Mac. Pero pareho lang yan collectively used as trademark or service mark. And itong collective mark. Collective mark means a sign designated as such in the application for registration and capable of distinguishing the origin of these goods. In the Philippines, meron tayo sa Guimaras mango. Pag ang mangga ay nanggaling sa Guimaras, meron ganong sticker tapos nakalagay yung logo na may letter G tapos tab mark Guimaras mangoes, meaning these mangoes, even if they are made or produced by different growers all over, they come from Guimaras, so they are supposed to be sweet. Yan yung collective mark. Okay? So, how about trade names? Trade name means the business, the enterprise. Trade names do not require registration as opposed to trademarks. Pero it's possible that trademark and trade name are the same. Example ulit, SM. SM shoe mark, diba? The S and the M appearances. That is also a trade service mark or trademark. But it's also the trade name. That's the name of the business. So, pwede naman pareho. Why do we have a trademark? They indicate the origin of the articles. They guarantee that they come to a certain standard. This is a form of advertisement. Okay. Now, to acquire trademark, we need the U, not just registration. You also file a DAU, a declaration of actual use, within 3 years from filing date. So let's go to what marks are not registrable. So those which are immoral, deceptive, scandalous. You remember the case of Harvard jeans, because in the Harvard jeans they would like Harvard University not to use the Harvard jeans logo. Diyos ko, ang kapalamukha ng Pilipinas, Harvard University in existence since 1800s. Okay? Now, flag or coat of arms of the Philippines or any political subdivision for a nation, name, portrait, or signature, identify particular living individual, identical with the registered mark, belonging to a different proprietor with reference to same goods, well-known internationally similar goods, well-known internationally dissimilar. I'd like to point this out kasi nandito yung mga cases natin. Even if you belong to the similar categories, there can still be delusion, trademark delusion. What is that? Lessening of the mark to be identified and distinguished regardless of the presence or absence of competition, confusion, mistake, or deception. Confusion can be either confusion of goods or confusion of business. In confusion of goods, the buyer would be buying one product in the belief that is buying another. In confusion of business, they are different, but the people may think there's some connection between the two. Okay, we'll discuss that later on in the case of Suyin. There are two kinds of delusion. Delusion by blurring and delusion by tarnishment. In delusion by blurring, it impairs the distinctiveness of the mark. In delusion by tarnishment, it harms the reputation of the mark. Example ng delusion by tarnishment. Levi's motorcycle na walang kinalaman ang Levi's jeans. But there are two different products. Pero can you allow Levi's motorcycle to exist? The Levi's mark? The answer is no. Because that is delusion by tarnishment. Paano kung Levi's motorcycle low class at sirain? Sabihin ng tao ay mahinang brand ang Levi's. So they will think that there's some connection with Levi's when there's not in the first place. So it's immaterial that the goods belong to different categories. Okay. Now to determine confusion, we apply two tests. The dominancy and the holistic. In dominancy, which is the law that we apply now, you look at the prevalent feature, kaya nga dominant. In holistic, you look at the entirety of the marks. We do not use any more holistic test. Sabi ko kanina, we go to the Suyin case. This is the bench case. Kasi itong Suyin, meron siyang salon. Nagbebenta rin siya ng hair products. Meron siyang brand ng gel. Ang pangalan ay Agent Bond. Sino umangal? Yung James Bond na franchise. Bond's Girl 007 and James Bond. These are the oppositors. Because they're saying that the dominant feature there would be the Bond. Which is true. Why? Why would of all words, why will Suyin choose Agent Bond? Agent Bond is a hairstyling product to bind straight hair. In the James Bond movie, it always depicts a man who is has a perfect kept appearance, ayos na ayos yung buhok, di ba? So, it's part of the package. So, people will think there's a connection between Agent Bond and James Bond. So, hindi na pwede. Okay? Now, the case of Mang Inasal as well as OK Hotdog Inasal. Yung Mang Inasal na inasal portion, yun yung kinopya, which is dominant feature. Pero sabi naman ng OK Hotdog Inasal, chichirya kami, ikaw restaurant. Pero kasasabi ko lang kanina, this is trademark delusion. And also, you will be depriving Mang Inasal should it engage in the manufacture of chichirya. Diba? In the famous case of the condiments, Papa Ketchup versus the Papa Boy Lechon Sauce. The dominant feature there is Papa. Although they belong to different category, one is ketchup, the other one is lechon sauce. They are both condiments found in the same grocery aisle. However, this Papa case was overturned apparently by the Citibank case, which is Citibank versus City State. This time, sabi ng Supreme Court, hindi dominant feature ang city. Anong dominant feature? Yung logo ng City State, merong lion. And it was the dominant feature there is the lion because the lion here is the merlion from Singapore. The owners daw ay Singaporean nationals. So, tandaan nyo, pag naglaban ang baboy at yung lion, ang panalo ay yung lion. Kaya matatandaan yung City State ang nanalo, hindi na yung UFC case. Now, the landmark case of Colin comes to mind. Noong una kasi 2015, pinayag ng Supreme Court na mag-coexist yung Colin na brand na merong generator set versus TV. Tapos, dumating later on, ngayon, 2021, yung Colin case na ang ay pareho, ay italicized, pero Colin pa rin. This time, sabi sa Supreme Court, you cannot coexist. Why? We are no longer following the holistic test, which is the one which we used in the 2015 case. Now, 2021, what we're using is the dominancy test, and the dominant feature there is Colin. And even if you say your I is italicized, it's similar to Caloocan with a K or Caloocan Cap with a C. Item sonants sounds alike. Okay? And now, even if they belong to different categories in the first place, they are all electronic naman. And then this classification changes from year to year. So you cannot use that as basis. Now, so in the case of naman Mr. Gulaman, which you see in the slide, the Mr. Gulaman is the prevalent feature. And the one who was able to obtain registration is not the owner. That is why the real owner was granted a right to cancel the registration. In the case of cherry fur versus CG fur, of you sounds alike. Moreover, the logo of cherry fur, the trademark, is a boy who's dunking a ball and he's wearing a cap. And the CG fur, on the other hand, it has a logo or trademark of a boy with a cap about to dunk a ball. So, pareho sila na mukhang mayroong correction. Okay? Pareho lang sila ng character. So that's why CG for later on changed its trademark to a girl, not a boy. And the famous lechon, LRs with an S and LRs with a Z. Before this case came out, personally, I thought nga na LRs with a Z is a franchise of LRs. This is really a proof that there will be deception to the minds of the public. So, the Supreme Court then disallowed LRs with a Z from using the bamboo tray device because LRs with an S was the one who was able to get registration. And even if you say that the appearance, the use of the word Z is different from S, idem sonans, sounds alike. Okay. Now, in Levi's versus Lives, sabihin nyo, teka, mag-iba naman eh. Ibang tunog, Levi's, Lives. But they're both clothing apparel. And Lives is an anagram of Levi's. So the court disallowed Lives from using Levi's. You cannot use the old Supreme Court case in which Lives won because that case, having the Supreme Court, it's not a trial of the merits. This is just a preliminary investigation. There was no trial. The trial happened in the 2021 Levi's case. Now, Lulaine or Lan, McDonald's versus McJoy. Sabi naman ni McJoy, spelling ng McJoy naman namin ni MAC. McDo MC. Again, immaterial. Bakit? Kalokan with the KNC, pareho lang tunog. Sabi naman ni McJoy, kaya naman McJoy ang pangalan ko. Hindi naman dimanda si Chicken Joy, si Jollibee, di ba? Pero McJoy kasi, yan ang palayo ko. Ano palayo mo? Scarlett, you cancel. Ang layo naman. Bakit yan ang pangalan mo? Para-paraan na rin, di ba? Now, later on, McDonald's versus LC Big Mac, ganun din. Big Mac with a K. Big Mac is with a C. So, and also, they are both selling burgers. Pero sabi naman ni Bel si Big Mac, hindi lang naman burger binibenta namin. Meron din kami siomay, siopaw, etc. Well, it's immaterial because the McDonald's should not be deprived should it wishes later on to venture into other food types. As if magbebenta ang Big Mac ng siopaw at siomay. Tapos sabi ni Big Mac, that is the name of the owner, of the parents of the owner. Anong pangalan? Si Maxima at si Kim Soy, kaya daw naging Big Mac. Parang laki din, ano? Now, in the Nestle case about the Master Rose and Flavor Master, there is infringement in the use of the word master because that is the dominant feature. Master Rose is by Nescafe is a product of its marketing scheme. But Flavor Master by I think this was CFC, copied Master Rose. And the word master was coined because of the commercials that these people are masters of their craft. They use Jaworski, De Here, and Rico J. Puno as their commercials. Kaya bantayan nyo yung Nutri-Asia tsaka Dali. Bakit? Ganun-ganto rin ang kwento because Dali copied the Nutri-Asia products. Look at their Dato Puti, soy sauce and vinegar, and the UFC ketchup. They have really a striking resemblance with the brands being sold by Dali. So this is an evolving case. Pero for me, obvious yung unfair competition here. What else? You cannot register those which will mislead the public as to the nature, quality, characteristic, or geographical origin. That's why if you say 5-year-old whiskey, dapat talagang 5-year-old. Or those which are generic. There is what we have a spectrum of distinctiveness. From the fanciful, suggestive, descriptive, down to generic. Generic is not registrable, pero yung fanciful, these are the strongest. This can be the subject of a mark. You say Kodak for film products. You don't find that in the dictionary. Okay. Arbitrary, these are random by reason of the choice. Okay, when you say family bank, it will also fall under arbitrary as well as suggestive marks. This can be registrable. But those which are descriptive are not. The only exception is the doctrine of secondary meaning. Remember the case of San Miguel beer versus beer na beer, where the words Pilsen were questioned. Sabi ng San Miguel, oy, beer na beer, bakit gamit mo words na Pilsen? Pwede ba yun? Sabi ng Supreme Court, pwede ang Pilsen because Pilsen merely describes the kind of beer. It is a kind of light Bohemian beer coming from the city of Pilsen in Czechoslovakia. Oh, wrong spelling wrong pag nilagay yung Czechoslovakia. Okay? So, there is one recent case. Ginebra, San Miguel, versus the Director of Bureau of Patents. What is it about? About Ginebra. Is Ginebra generic? Kasi sa Tanduay, merong gin kapitan. Ginebra. Okay. Now, to determine whether or not it is generic, you look at public perception. Because in the minds of the public, it is generic if it understands the word as merely referring to a general class. But if the public understands that that word pertains to a particular enterprise, it is no longer generic but distinctive. Here, there was the Supreme Court applied the doctrine of foreign the Supreme Court, you looked at the doctrine of foreign equivalence. What does it say? It says that words that are foreign equivalents of generic or mere descriptive may not merit legal protection if consumers recognize the generic term. For example, yung Lyceum. Lyceum is not registrable because when you say Lyceum, it does not mean automatically Lyceum the Philippines. Other liceos, Bisbate, Pangasinan, etc., who are allowed to use the word liceo because liceo means school. Pero yung Ginebra, in this case, anyway, you have them on the slide. When they have to market research where the result is, if you say Ginebra, people associate it with San Miguel and nothing else. That's why what was applied here is the doctrine of distinctiveness, the doctrine of secondary meaning. Kasi sabi nila, Ginebra is generic, but because of the long time use, more than 180 years, it was used by San Miguel. It was associated minds of people to pertain to Ginebra San Miguel. Because are you aware that Ginebra means Genever or Genever, the juniper berry flavored gin, specific kind of gin. So parang San Miguel Pilsen, di ba? Parang ganun dating. Pero hindi eh. Ang Ginebra, nag-stick na sa minds ng public na belonging to San Miguel. Okay? Take note of this case as well as the discussion you see in the slide. So what else? The beer na beer case. In the beer na beer, there was a question about shape. Can you register a shape? Well, shape unless necessitated by technical factors. Kasi sa San Miguel versus beer na beer, parang silang elongated bottles. Ang shape pataba. Pero sabi ng Supreme Court, they are standard packaging for liquor. Okay? Well, the only exception is if it's necessitated by technical factors. Kasi sa other jurisdiction, we have shape mark, not here. Halimbawa, Nissan Cup noodles. May ridges ang Nissan Cup noodles, making it registrable. That is the reason. But not just because it is a cup. For color alone is not sufficient. Unless you give a definite form like the 7-Eleven. Hindi lang color yan. The scheme, that's why it is registrable, being a color mark. And the last item is being contrary to public order or morality. So I mentioned already the Lyceum case, and there is a runner-up case, the Shangri-La case, where a Shang Properties case, which is about the St. Francis Square. St. Francis does not acquire secondary meaning. So it cannot be appropriated by St. Francis Square. That's why St. Francis Development was able to use the word St. Francis. Now, a mark can be cancelled if it becomes generic, or it was abandoned, it was fraudulently registered, or failed to comply with the U. But the use of a mark in a form different from that registered will not, as long as it does not alter distinctive character, will not be a ground for cancellation. Now, when you use a mark in the internet, in the website, is that automatically protected? To constitute use, it must be shown to result into a within-state sale or targeted customers which reside in that country. In the case of W Land versus Starwood Hotels, this was present because they presented reports where the sales from the Philippines using of Starwood Hotels was this much. They are using a toll-free Philippine number. You can buy, you can book hotels even if there are no hotels here in the Philippines, Starwood Hotels. But the website is written in English, a language known and used here in the Philippines. You can also pay in peso. That's the thing to distinguish infringement versus unfair competition. Sa dalawa, anong mahirap? Mahirap yung unfair competition because of the requirement of proving the fraudulent intent, which is not required in infringement. The cause of action infringement is the authorization of the mark. In unfair competition, it is the passing off. Registration in trademark is required. Unfair competition is not. When you say passing off, you make it appear that your goods are that of your competitors. Example, in the case of San Miguel versus Foods Fair, Pure Foods versus CDO. Pure Foods Fiesta Ham and CDO Pista Ham. Ano nangyari? Hindi pwedeng pista. Which is a loose translation of Fiesta. That is unfair competition because they're passing off Pista Ham as that of Fiesta. They even change the box to make it appear that they're similar to Pure Foods. Okay. Also, in the case of Cobb versus Somerville, which is the Chin Chun Su. Before kasi, what we thought is that if there is a name of a manufacturer, there's no unfair competition. But the Chin Chun Su case changed it. Because sabi ng Supreme Court, even if you put the name of the manufacturer, do people look on the name of the manufacturer? Or they just recognize, uy, parehong pink, uy, parehong oval, uy, parehong nakasulat Chinese character, Chin Chun Su. Okay? Now, in Petron versus Yao, it is about refilling of cylinders. Because Masagana Gas had been refilling Petron and Shell with Masagana Gas. And this is unfair competition. But can you file separate cases or just one case? Kasi ni-refill si Cavite dito. By the way, this they had a case with me also, this kind of case, which went to the Court of Appeals. And then, nagbenta sa Manila, Makati. Ibig sabihin, lahat yan may unfair competition. Sabi sa Supreme Court, isa lang. Doon sa Cavite, ang unfair competition. Because the violation of the law is just continuing. Okay? Just file one case of unfair competition. Pero, who will file? Is it the public who were deceived na, ay, binili namin, ay, hindi pala Petro, hindi Masagana Gas? Or is it the owner of the mark? The Supreme Court said that the owner of the mark is the one who should file because the benefit given to the consumers is only incidental. Because this law is for the protection of the owners of the mark. Okay. So, bottle hoarding, remedies for infringement. We'll just skip this part. Let's go now to copyright. Now, for copyright, remember that what is protected is only the expression of the idea and not the idea itself. That is what we call idea-expression dichotomy. If just an idea, you cannot be protected. It must be fixed in a particular form. So there are two categories of copyrighted works, original and derivative. A derivative is a work based on a pre-existing work, but original can either be oral or written works. Example, the book, you were able to write a poem, pero nakalagay lang sa libro o notebook mo, hindi mo pinublish. Nanakaw ng classmate mo yung libro mo, kinopya yung poem at pinublish niya. Is there infringement? The answer is yes. Even if hindi mo naman pinublish ang libro, ang poem mo is immaterial. Publication is immaterial because copyright is given from the moment of creation, not registration. Halimbawa, oral works. Paano yung lecture na to? Halimbawa, meron nagre-record na iba, tinatranscribe. That's also a violation. Okay? It falls under original work. Paano kung letters? What you own is only, the recipient only owns the physical, not the copyright over the letter. Meaning, kung letter na yun ay may poem, hindi mo pag-aari yung poem, ikaw na nakatanggap ng letter na yun. Ang pag-aari mo lang yung papel, but not the poem. Okay? So for dramatic o music composition, choreographic works, entertainment and dumb shows, anong choreography? Ang sayaw ba ay pwede? Hindi pwede ang mere dance move or dance pose. Kailangan choreography. Choreography means composition and arrangement of a related series of dance movements. Entire, organized o coherent whole. Hindi just a pose. Okay? So music, melody, lyrics, works of drawing, painting, architecture, or recall. Ikaw ay nagpunta sa Louvre, sa France, pinicturan mo, and then, yung si Mona Lisa painting, okay? Ginawa mo coffee table book yung drawing ni Mona Lisa. Pwede ba yun? Well, that is covered by copyright. But the problem is, sino ba ang gumawa nung Mona Lisa? Diba? Long time dead. Leonardo da Vinci. Okay? So, there's no more protection. What if nagpagawa ka ng nude painting sa isang artist? At tapos yung nude painting mo ay pinakopya mo sa isang 4th year student ng fine arts. Gumawa siya ng look-alike. Pwede ba yun? There's a violation also of copyright. Okay? Because what you own is only the physical picture. Now, maps, drawings, photographic works. Regarding photographic works, eto, natanong na sa bar, may isang celebrity nagsiswimming sa beach. Nakunan siya ng picture ng paparazzi na appear sa newspaper. Can this celebrity cry copyright infringement? The answer is no. Because copyright is owned not by the subject. It's owned by the photographer. Sample, kumain kayo magkakaibigan sa restaurant. Tapos binigay mo yung camera kay waiter. Sabi mo, Kuya waiter, picturean mo kami. Tapos sabi ng waiter, sige miss, compress. Miss, ano lumalabas ka sa frame? O miss, jump shot. O yan. Who owns copyright? It's owned by Kuya waiter. Why? Because the selection, the arrangement, the lighting, he has choice. But if the mere job of the waiter is to click on the button, that's different. The copyright is owned by the one who instructed. Not by, remember, copyright is not owned by the subject or the owner of the phone, but the one who took the photo as well. Okay? Remember the famous case of the monkey who made a selfie na pinag-awayan sa Amerika kung sinong may-ari talaga ng copyright. Siyempre, hindi yung monkey. Talo yung monkey. Wala naman siya legal personality. But the photographer here is the one who owns copyright over the same. Pero it ended into a settlement. So we don't really know had the trial been pushed. Cinematographic works, so palabas sa TV, sa movie, film, cartoons, computer program, others. The law here says others. Therefore, paano kung porn? Copyrightable ba ang porn? The law does not make any qualification between chaste and unchaste, as opposed to trademark and patent where there's a moral utility clause. In copyright, there's none. Why? Because they always claim this is art, and art is subjective. So, this is not a closed list. Okay? Now, for derivative work, it's a work based on a pre-existing work, like a translation, dramatization, adaptation. Libro, ginawang pelikula, ginawang play, or like the Harry Potter, which is a famous one, or telenovela nakadapt into Korean. So others would be collection of literary, scholarly, and artistic works, which are original by reason of their contents and choice. The landmark case of Republic versus Tupas comes to light. Ito yung case na, by the way, my lecture would have to be only up to intellectual property, but the materials I will be sending is the entirety. Okay? Now, in the case of Republic versus Tupas, sabi ng Philippine National Police, Oy Tupas, pwede bang i-revise mo ang badge ng PNP? Meron pa rin 3 stars, meron pa rin 8 rays of the sun, meron pa rin lapu-lapu, meron pa rin shield, may laurel. So, bahala ka na sa arrangement. So, sabi ni Tupas, okay. So, when Tupas made the new logo, he was able to get a copyright. The government opposed and asked for cancellation. Pero sabi ng Supreme Court, the copyright belongs to Tupas. Why? Because the government, the republic, merely contributes an idea. The one who expressed the idea is Tupas. Therefore, he is the author. Okay? Now, where there are non-copyrightable works, meaning these are not protected like a mere idea, because it's just there in the mind. Okay? Like a method of a dating game in the case of Joaquin versus Drilon, or like in the case of Willie Revillame, when he moved channels, the methodology of a game, of a radio show, TV show, is not copyrightable. News of the day, like if someone was able to make a news on the current events now, anyone can make about it. But once it is placed in the newspaper, it's a different thing. In the case of ABS-CBN versus Gozon, when Angelo de la Cruz arrived in the airport, what Channel 7 did was to tap into the footage of Channel 2 indirectly. And that is a violation of copyright because the footage is owned by Channel 2. Okay? Official text. The law says official text. Therefore, hindi kasama dito ang pagpapasirox ng SCRA na pag-aari ng Central Books. Tandaan, ha? Hindi official text yung SCRA, kaya nga SCRA ang may annotation. Copyright which had already lapsed. Okay? Itong copyright which had lapsed, I recall writing an article which is published in SCRA as well as in a Japanese publication when I was there in Japan for intellectual property. Sample. Little Mermaid. My topic there is about mystification. Little Mermaid. Ano yung ending ng Little Mermaid ng parood niya sa Walt Disney? Di ba? Happily Ever After? Dahil si Little Mermaid at si Prince ay nagkainlaban. Pero ang totoong Little Mermaid ni Hans Christian Andersen ay sad. Dahil nag-suicide siya. Dahil nakita niya na yung Prince in love with another woman, hindi niya kayang saksakin using the knife na binigay ng mga sisters niya ng pakalbo. Hindi niya kaya, so nag-suicide siya. Pero di ba napanood sa Little Mermaid? Hindi. Pero pwede ba umakas si Hans Christian Andersen? Hindi. Bakit? Copyright has already lapsed. Meaning, the right to question that's the moral right of integrity of authorship, you cannot question anymore because he had long time lapse. The right had long time lapse. Okay? So, who owns? Pareho ito sa rule sa trademark. You just breeze through the material. So, if you are a copyright holder, you have the right to the reproduction of a work or substantial portion of the work, dramatization, the public distribution, as well as the rental. Okay. Now, I have to highlight here jurisprudence regarding limitations. Because we have 3 new cases. One of the limitations of a copyright owner is that if there's already a recitation, once has been lawfully made to the public, privately and free of charge, or made strictly for charitable reasons to society. We have the case of Philscap, Cossack, and Iceberg. This, by the way, is the article which I wrote, which is submitted in Geneva, Switzerland for the Colloquium for Teachers of Intellectual Property last November. Ang kwento ng Philscap and Andre, tsaka Iceberg versus Philscap, pareho lang. Kapag there's music played using the loudspeaker on a restaurant, it's there tuned into a radio station. Is there copyright infringement? If a live band is playing copyrighted songs in a bar, playing music, is there infringement? The answer to all of this is yes. Why? If the restaurant is playing music while tuned into the radio, which is using a loudspeaker, that is already another performance. That is what we call the doctrine of multiple performances. So, a performance can result to multiple performances when you use this loudspeakers. That's why there's a need then to pay royalties anew. Now, you cannot use fair use as an excuse because for fair use to apply, it must be privately and free of charge or made strictly for a charitable or religious institution society, which is not applicable here because here there is payment and also this is not private, this is public, this is a restaurant, this is a bar. So you cannot apply the doctrine of fair use as well as the 4-factor test. Pero sabihin nyo sa US, di ba meron namang copyright exemption, the business exemption and home sale exemption? However, these exemptions are not present in our law. That is why this, under jurisprudence, this was thrown to Congress for the Congress to make a change in the law. Ewan ko lang kung gagawin nila ito as soon as possible. Okay? So, limitations, fair use, mass media, leave this up to you. Legal proceedings for the purpose of giving legal advice. So fair use. Remember the ABS-CBN versus Gossip case. Now for infringement happens when there's direct commission. You benefit from the activity of another, provided you have been given control and ability to control, not ability to control, and or you with knowledge you contribute to the activity of another. For example, what if a mall operator has a tenant who's selling pirated materials? Is the mall operator also liable for infringement? It depends. Because the mall operator must not have only knowledge, but also ability to control the activity. So this is where mall owners use as their excuse. Okay, I know we're cramped for time because this is already beyond the 3-hour scope. Pero I'm leaving nonetheless the material for you regarding data privacy kasi konti lang naman to, self-study, kaya nyo naman ito. Followed by Securities Regulation Code, konti lang coverage ng SRC, particularly the Howey test. And then, in so far as the e-commerce and electronic evidence, konti rin naman ito. The cases are also highlighted here, which you will see. And then, the last topic here would be on access devices regulation, which is new under the law. Wala pa itong natanong sa bar ever. Pero kung sakali may tatanong dito, naisip kong maganda, kasi baka kumakalimutan, is in so far as intent to defraud. Kasi uso ito ngayon. Halimbawa, hindi ka nagbayad ng credit card, may utang ka, 50,000, hindi ka nagbayad, lumayas ka ng bahay mo. What then will happen? That is also, that would fall as intent to defraud, because if you leave without informing your change of address or change of employment, 90 days outstanding balance, more than 200,000, this is prima facie presumed that was done with intent to defraud. Okay? So, I hope that you will, anyway, you can also see the details of my lecture in my pre-week, and it was an easy read for you. Okay? So thank you for listening. And again, if you're enrolled in any bar review school, you can again hear from me. May Philippine Competition Act pa rin dito pala kasama, pero kaya niyan, kaya rin yung mabasa. Okay? So thank you for listening.
And that was it for our lecture for today. We would like to thank, of course, Judge Tambasacan for the very insightful lecture. As a matter of fact, we were able to list down, perhaps some of you, our viewers, you were able to list down the highlights of the lecture for today, such as corporation, transportation laws, insurance, partnership, as well as banking laws. And the very last one, which is very interesting as well, intellectual property law. For our series, just like what I mentioned in the beginning, we have a series of lectures, and today, commercial law is just one of the many subjects that we're going to cover in this lecture. We have lectures on the following subjects: political and public international law, labor law, and social legislation, taxation, civil law, criminal law, remedial law, as well as legal and judicial ethics with practical exercises. And we would like, before we formally end the lecture for today, we would like to thank our generous sponsors for today. Of course, we have the Association of Law Schools in the Philippines. Thank you very much. Maraming salamat po. As well as Central Books. Maraming salamat po. Apart from providing us with high quality books, you are giving us free lectures as well as the Polytechnic University of the Philippines College of Law and the ALSP, or the Association of Law Students of the Philippines National. And that's pretty much it. Again, my name is Leonard David Espiritu. Maraming salamat po sa panonood ngayong araw nito. Ingat po kayo lahat.